All right, everyone. I don't think we have a microphone, so my voice will have to do. So thank you, everyone, for joining us today. Thank you to all of our distinguished speakers for making the trip out to Macon, just to make this weekend so special for us. Thank you to all of the Law Review members, each of you for making it last night and for giving us your Friday for this special symposium. My name is Devin Joyner. I am the lead articles editor on the Mercer Law Review. As such, I played a small role in putting this symposium together, and it is very gratifying that we are finally here this weekend. I wanted to start out first by thanking again John Davidson for his tremendous keynote speech last night. Absolutely. Last night and this morning, I've really been reflecting on some of the things that Mr. Davidson said in his speech last night that are so applicable to us today, not only with respect to the Freedom to Marry movement, but just with our social climate right now and the time we spend here as law students. First was the role that he spoke about individuals coming out of the closet played in the Freedom to Marry movement, and just what that really meant for being true to oneself, being open, being transparent with the world, and the power that that had to change minds and to really affect people throughout the Freedom to Marry movement. I think that's a lesson that we can all take for just being transparent with ourselves, being open and candid, and just not being afraid to try to reach people. As a corollary to that was the role of honest dialogue and conversation, the role that that played in changing people's attitudes with respect to the Freedom to Marry movement. Mr. Davidson said, and I wrote it down, that it was important to listen to real people who had real concerns with respect to the Freedom to Marry movement. It was important to go talk to these people, to address those real problems through honest, frank conversation, and just the importance that role played within the movement. I think there's perhaps no finer lesson that we can gain as we sit here as law students today in our ever-changing legal and social climate, that we must root our principles in civility and respect for others, but we must also be willing to go out and meet people, to go out and talk to people and have honest conversations about our positions. I think that should be a foundational principle for us as law students, as citizens, and as future attorneys. So once again, I want to thank John Davidson for last night. These were the exact insights that I was hoping to gain from this symposium this weekend. So while last night we got to hear from a pioneer of the Freedom to Marry movement and a foot soldier of the Obergefell decision itself, today we get to explore the legacies of that movement. Our panels today will explore exactly that. Today we will first hear from a pair of legal scholars, Professor Marcia Zug from South Carolina Law School, from Professor Jess Feinberg from the University of Maine. We will hear from them today on the family law legacy of the Freedom to Marry movement, the rise of AI relationships and what that means for the Obergefell decision, what it meant for their legal legitimacy, and what the Obergefell decision meant and continues to mean in the context of non-traditional family structures. Today we will also hear from constitutional law scholars and practitioners, from Professor Eric Siegel from Georgia State Law School, from John Davidson, and from Professor Susanna Goldberg from Columbia. They will come to us today to explore the constitutional law legacy of the Freedom to Marry movement, the decisions that led up to the holding in Obergefell, and to the durability of the Obergefell decision in light of jurisprudential change on the Supreme Court. Last today, we will hear from a mix of scholars, practitioners, and movement leaders within various civil rights movements. Today we will hear from Ms. Adelina Nichols, Professor Susanna Goldberg from Columbia, and Mr. Shannon Minter on the shared lessons between civil rights movements and what impact the Freedom to Marry movement had on pursuing the goals of various minority groups. I greatly look forward to our time today and hope that this event is as fulfilling to each and every one of you as it has been for me in putting this together. So I'll now turn it over to our editor-in-chief, Seth Lewis.
Good morning, everybody. For those who were able to join us last night, they know the personal meaning of this event to me, but today I'm speaking on behalf of the Mercer Law Review. On behalf of the Mercer Law Review, I'd like to express our sincere gratitude to the many faculty, staff, and law review members that have helped make this event happen today. I would also like to extend a special thank you to our panelists. We're so grateful for you to come and join us and discuss the legacy of the Freedom to Marry movement. Now, a few of the goals of the Mercer Law Review are to advance the study and development of the law and to provide a forum for the expression of ideas. In my eyes, our annual symposium is one of the most important tasks that the Law Review undertakes that allows for us to achieve those goals. Now, sometimes I find myself wondering, while we strive to push the discussion forward, why do we do so? What is the true purpose behind the work we put into our published articles and into planning our symposium? I think that the answer to that question is what makes this year's event particularly special. This year's symposium goes beyond the articles and the discussions, and instead focuses on what makes our profession, or the future profession for some of us, truly powerful. It is my opinion that the reason for why we strive to advance the study and development of the law and to provide a forum for the expression of ideas is because of the real-world outcome that stem from those discussions. In 1983, as a third-year law student at Harvard Law School, Evan Wolfson wrote his thesis on the freedom to marry, asserting same-sex couples' claim to this constitutional right. The freedom to marry movement was born from discussions, just like what we will have today. Eventually, these discussions led to actual change. The reason for why I think this year's symposium is truly special is because it shows how events like today's symposium or the articles that we work so hard to publish can change the legal landscape. Now, without further ado, it is my pleasure to introduce our wonderful Associate Dean for Academic Affairs, Dean Wilkins.
Good morning, everybody. Speaking on behalf of Dean Snedden and the law school and university administration, welcome to the Fall 2025 Mercer Law Review Symposium. You are in for a stimulating and even a compelling day. This year's topic, I think we all know, the Freedom to Marry movement, Legacies and Lessons, is both important and timely. Frankly, I'm personally excited about all of the panels. I'm really looking forward to the day. Thank you to everyone who made this symposium happen. First, to our many panelists, we are honored by your presence today. To a person, your work in the legal profession and in the world has been consequential and mission-driven. One of our particular priorities at Mercer Law is what we call professional identity formation, which includes the integration of one's professional life with one's personal values, and you exemplify that for our students. So thank you. We're looking forward to learning from you today. Thank you for coming and for being our guests. Thank you also to the many, many others, there are always a lot of thank yous, who made this symposium happen. Of course, Devin Joyner, lead articles editor, Seth Lewis, Law Review editor-in-chief, both of whom have done all the things. Labor is visible and invisible, and that's true for Law Review students generally. Chauffeuring, making name tags, doing whatever it happens to be. To Law Review faculty advisor Caleb Byers, to Associate Dean for Faculty Research and Development Scott Tidshaw, who proposed this topic and who has worked tirelessly both with the Law Review and with our panelists. To our moderators, Professors Carlson, Simpson, and Tidshaw. Let's not forget IT. IT always matters. So our IT director, Chris Ozier, and the entire IT staff, our Director of Finance and Operations, Tracy Jackson, our Dean of Students, Jeannie Zipperer, our Law Library Liaison to the Law Review, Savannah Nolan, and I'm going to name somebody who makes this building run. The Dean's Executive Assistant, Bernadine Jackson, who has jumped in 1,000 ways, So thank you to all of you, and thank you again, especially to our panelists. We are grateful that you're here, and we look forward to learning from you. And without further ado, I'll turn it over to Dean Tidshaw.
Thank you. Yes, I just have a couple of things to say. I have more thanks, I guess, and in particular, I know a lot of people on the law review have been very helpful, involved in this entire process, but I'm just going to single out Devin Joyner and Seth Lewis, who have worked on this tirelessly with me since February. We spent a lot of time together dealing with things that have come up, and I will also point out that they in particular have overcome significant challenges as this went forward, even over the last week. So I really appreciate all of their hard work in doing that. I wanted to point out that part of the idea for this was not only to celebrate the Obergefell versus Hodges decision, which was decided 10 years ago on that anniversary, and that was sort of the impetus for doing this at this time, or for suggesting at this time, but also I wanted to mention, really the idea for this was to go beyond that decision and celebrating some decision in the past, and to deal with where we are today and maybe in the future, to consider the movement that led to Obergefell and lessons that we may have gleaned from that, both good and bad lessons, from failures as well as victories, and also to consider where the legacy of that movement is today, and where things stand today as well as where they may stand in the future. The last thing I wanted to do is, and I'm going to keep this very short, but I wanted to remind you all that Mercer is a community of respect, that we value open discussion and civil discourse, but do be respectful of the professional environment, and I request that audience members not interrupt speakers or participants. I'm sure you won't. And also mention that if you are disruptive, you may be asked to leave. So hopefully that will not be an issue. I'm sure it won't. But here's to lots of open and civil discussion. So.
Good morning, everyone. My name is Jody Scott, and I serve as managing editor for Volume 77 of the Mercer Law Review. I have the privilege of introducing our first panel of the day, the Family Law Legacy of the Freedom to Marry Movement. The Freedom to Marry movement sparked sometimes unintended reactions, including accelerated legal recognition of non-marital partners and new alternative legal institutions such as domestic partnerships, civil unions, and reciprocal beneficiaries. This panel will likely explore the path and the resilience of these legal innovations for same and different sex couples. Obergefell and its progeny, Pavin versus Smith, have also raised family law questions that have yet to be definitively resolved, such as the constitutionality of discrimination and parentage presumptions between same and different sex spouses. Finally, the panel might also address possible legal recognition for polyamorous relationships, which have since been discussed since Obergefell. On this panel, we will hear from Professor Jessica Feinberg, a professor and associate dean at the University of Maine School of Law, and Professor Marcia Zug, the Miles and Ann Lodeholt Professor of Family Law at the University of South Carolina. Before we begin the panel, I would like to introduce our moderator, Professor Bonnie Carlson. Professor Carlson is Director of Experiential Education and an Associate Professor of Law at the Mercer University School of Law. Prior to joining the faculty at Mercer University, Professor Carlson was a clinical teaching fellow in the Domestic Violence Clinic at the Georgetown University Law Center. In that position, she co-taught the clinic seminar and supervised clinic students in their representation of domestic violence victims in the Civil Protection Order litigation. Prior to working at Georgetown, Professor Carlson was a training and technical assistant staff attorney with the American Bar Association Commission on Domestic Violence and Sexual Violence. In that position, she wrote training curricula and publications for attorneys practicing domestic violence law around the country. Prior to this position, she was a family law staff attorney for the Alexandria Office of Legal Services of Northern Virginia for 4 years, representing victims of domestic violence. Professor Carlson graduated from the University of Virginia and received her JD from the George Washington University School of Law. With that being said, I will turn it over to Professor Carlson.
All right, good morning, everyone. I'm Professor Carlson. I'm really excited to be here today and especially to be moderating this panel. We're going to be hearing from two speakers today. Unfortunately, Professor Washington had an issue come up at the last minute and is not going to be able to join us today. But we will be hearing from Professor Feinberg and Professor Zug, starting with Professor Feinberg. And so I'm just going to introduce her briefly. So Jessica Feinberg is a professor of law and associate dean for research at the University of Maine School of Law. Before law school, she served as a fellow and organizer for the National Gay and Lesbian Task Force in New York. After graduating, she clerked for Judge Michael R. Murphy in the United States Court of Appeals for the 10th Circuit. She's since worked as a professor at DePaul University College of Law, Tulane University Law School, Mercer University School of Law, go Bears, and the University of Maine School of Law, focusing her scholarship on family law's intersection of sexuality, sexual orientation, and gender norms. During her time at Mercer Law, Professor Feinberg served as the faculty advisor for the Outlaw Chapter and chair of the school's diversity committee. Professor Feinberg is currently drafting an article, which we'll hear about today, that explores whether laws that punish non-monogamous conduct by married individuals without regard to whether the spouses have agreed to consensually non-monogamous marriage structure violate the fundamental constitutional right to marital privacy. Professor Feinberg graduated magna cum laude from Boston University and received her JD summa cum laude from Washington University School of Law. So I'm really pleased to introduce Professor Jessica Feinberg.
Good morning. Thank you all for being here. So, as was mentioned, I spent the first 9 years of my teaching career at Mercer Law, and it was a really formative experience for me. I have many wonderful memories of time spent with engaged students and faculty who are doing important work. This is a really special place, and I'm very happy to be back for this wonderful event. While I was here, my scholarship focused on LGBTQ plus rights, and I was always supported in that work by the administration, by the faculty, and engaged students here. And so, so much of my work stems from my time at Mercer Law. It's a great place to be. So my talk, as was mentioned, is going to focus on the issue of legally mandated monogamy within marriage. I spent the summer working on an article about this topic. I think the time has come, maybe past, right, the time to discuss this topic as we reflect on what marriage has been in the past and how it should look moving forward. In particular, what degree of freedom and autonomy people should have within the institution of marriage. So in recent years, an increasing willingness has emerged within U.S. society to challenge the idea, which has long been advanced by the law, that strict monogamy is the only acceptable structure for intimate adult partnerships, especially marriages. Today, approximately 1 in 5 adults reports having participated in a consensually non-monogamous relationship at some point in their life. Consensual non-monogamy, or CNM, as I'll refer to it, is a broad term. It encompasses a variety of relationship structures in which the parties involved generally are not confined to sharing sexual and/or romantic connections with only one partner. While there exists a potentially limitless variety of ways to practice CNM, and I have footnotes about each one in my article, which was quite an endeavor, the foundational thread among all forms of CNM relationships is that everyone involved is aware of and has consented to the non-monogamous nature of the relationship structure. So as CNM participation and visibility has increased, societal views regarding the essentiality of monogamy within marriage have become more nuanced. So while almost 90% of Americans believe it's morally wrong for a married person to engage in extramarital sex without the consent of their spouse, right, otherwise known as cheating, almost 50% of respondents to a 2023 Pew Research survey believed that consensual non-monogamous marriages either were acceptable or had neutral feelings on the topic. The law, though, long has and continues to punish marital non-monogamy in significant ways, and it generally does so without regard to whether the spouses agreed to a non-monogamous relationship structure. So in my article, I argue that this is not only problematic as a policy matter, which is something other scholars have pointed out, but also that such laws violate the fundamental constitutional right to marital privacy. So non-monogamy has been practiced for centuries in various forms across a range of cultures. In the early days of the United States, the most visible form of non-monogamy was polygyny, which is a form of plural marriage involving one husband and multiple wives. This was historically in the United States associated often with Mormonism. Polygyny was openly practiced during the Mormon migration to Utah, and it was plagued with a number of really serious issues. The structure involved the subordination of women and girls to men, and abuse occurred with disturbing frequency. I think one of the major difficulties encountered by those who practice CNM today is the still common societal conflation of all non-monogamy with the historical practice of polygyny, which, by the way, now has long been prohibited by the Mormon Church. So plural marriage directly contradicted the Christian beliefs shared by most U.S. settlers that the only acceptable form of marriage was the two-person, monogamous, lifelong structure consisting of one man and one woman. The settlers' response to the practice was severe. Plural marriage was punishable by death under the laws of England, and all of the colonies adopted some form of that approach. Notably, though, in seeking to mandate monogamy, U.S. laws went far beyond banning plural marriage. Early laws criminalized both sex by a married person with somebody other than their spouse and non-marital sex, identifying adultery and fornication as crimes against morality. In some colonies, adultery was punishable by death. And in some, right, the adultery and the fornication laws worked together to establish marriage as the only acceptable setting for sexual conduct. Notably, many of the early laws regulating monogamy were gendered. In some jurisdictions, only married women could commit adultery. Married men who engaged in the same conduct committed a lesser crime. Women were more frequently punished for adultery and fornication than men. In addition to divorce in some jurisdictions, a wife would need to show that her husband lived in adultery, while a husband would need to prove only a single act of adultery by his wife. The law's gendered approach to monogamy was in significant part aimed at maintaining men in the dominant position by controlling women's sexuality, protecting husbands from the shame that attached to the failure to control their wives' sexuality, and ensuring that husbands' property was protected and that husbands were not responsible for other men's biological children. Adultery laws explicitly differing treatment of men and women persisted until the 1950s in some jurisdictions. Enforcement of criminal adultery laws declined substantially after the 19th century as social values around sex began to liberalize. Prosecutions became significantly more rare throughout the 1940s and 50s, and the free love movement of the 60s reflected cultural shifts around sexual freedom. In 1962, the ALI removed adultery from the Model Penal Code, citing the ineffectiveness of adultery laws and the invasion of personal liberty perpetuated by the criminalization of adultery. Concern with the invasion of personal liberty by laws criminalizing sexual activity between consenting adults came to a head in the 2003 Supreme Court decision Lawrence v. Texas. There, the court struck down as a violation of the liberty protected by the Due Process Clause, a statute that criminalized sexual conduct between individuals of the same sex. The court relied on an earlier line of cases in which laws restricting the use or distribution of contraceptives were struck down. According to the court, those cases established that individuals have the right to make certain decisions regarding private sexual conduct, and that this right is not dependent on the individual's marital status. The Lawrence Court further noted that the law at issue touched upon the most private conduct, sexual behavior, and in the most private place, the home, and that the law sought to control a personal relationship that, whether or not entitled to formal legal recognition, is within the liberty of people to choose without being punished. In striking down the law, the court held that the fact that the governing majority has traditionally viewed a practice as immoral is not a sufficient reason for upholding a law prohibiting it. Unfortunately, the court's failure to explicitly categorize the right at issue as a fundamental right or to identify the level of scrutiny it was applying detract to some degree from the force of Lawrence in challenges to other laws targeting private sexual conduct. Importantly, criminal law is far from the only means through which the legal system has sought to mandate marital monogamy. Civil law has long played a critical role in promoting monogamy within marriage and also expressing the state's disapproval of non-monogamous conduct. Adultery has the distinction of being the oldest fault-based ground for divorce. In some states, it was the only ground available for divorce. In addition, adulterous conduct was commonly punished through divorce laws governing spousal support, property distribution, and child custody as well. Today, the law continues to punish marital monogamy, non-monogamy in a number of meaningful ways. Although enforcement is rare, adultery remains a crime in around 16 states. Notably, none of the existing criminal adultery laws distinguish between consensual and non-consensual non-monogamy. In terms of civil law, adultery remains a ground for divorce in most states. In addition, in many jurisdictions, misconduct during the marriage, including what the jurisdiction identifies as fault-based conduct, such as adultery, is a factor for courts to weigh in property distribution and alimony determinations. In a few jurisdictions, a spouse who is found to have engaged in adultery is just barred completely from receiving spousal support. In addition, in some jurisdictions, adultery is a factor that courts can consider in child custody determinations. So laws that serve to punish people for choosing a CNM structure for their marriage implicate the fundamental constitutional right to marital privacy. In the seminal 1965 case, Griswold versus Connecticut, the Supreme Court explained that the marital relationship falls within the zone of privacy created by several fundamental constitutional guarantees. The court held that a law banning the use of contraceptives by married couples violated the spouse's fundamental right to marital privacy. Notably, the court declared that a law that allows the police to enter into marital bedrooms in order to search for contraceptives is repulsive to the notions of privacy surrounding the marital relationship. Yet, the state entering the marital bedroom is exactly what occurs when the law punishes non-monogamy without regard to the private agreement between the spouses regarding the structure and rules of their marriage. More recently, in Obergefell, the court stated that the right to personal choice regarding marriage is inherent in the concept of individual autonomy. The court reaffirmed marriage as a fundamental right and stated that, like choices concerning contraceptive, family relationship, child rearing, decisions concerning marriage are among the most intimate that an individual can make. While there's a strong argument that laws that punish consensual non-monogamy violate the liberty interests of married and unmarried individuals alike, my article focuses on that violation in the context of married individuals. I think that starting there is a logical choice for a few reasons. First, current laws that punish non-monogamy generally target marital non-monogamy. In addition, starting with the potential violation of marital rights makes sense given the line of Supreme Court decisions that I just talked about relating to the Due Process Clause protection of privacy and liberty in the context of intimate decisions about issues like marriage, family, sexual conduct, and procreation. In the cases that involve the protection of intimate choices relating to marriage, the identification of the right at issue as a fundamental right is clear. This is not as much the case for the decisions involving non-marital intimate conduct. So when a law interferes with the fundamental right, we know that it's subject to heightened scrutiny, right? That the law must be closely tailored to a sufficiently important state interest. Current laws that punish marital non-monogamy directly and substantially interfere with the fundamental right to marital privacy, I argue. These laws inject the state into the marital bedroom and create a dynamic in which the state and not the married couple gets to decide what type of private consensual sexual conduct is permissible within the marriage. So laws punishing marital non-monogamy without regard to whether it's consensual in nature, I argue, fail to pass heightened scrutiny. I think there are a number of potential state interests that proponents likely would set forth as justifications for such laws. And so when considering the history of laws punishing marital non-monogamy, it seems clear that morality has been the driving force and primary justification for such laws. Under Lawrence, however, the state's view of a particular practice as immoral does not create even a legitimate, let alone important, state interest in prohibiting the conduct. While other potential justifications for laws punishing marital non-monogamy arguably may rise to the level of an important state interest, I argue that these laws are not closely tailored enough to pass scrutiny. So, for example, the promotion of marital satisfaction and stability may be set forth as a state interest. However, social science research indicates that relationship quality does not differ significantly between monogamous and C&M relationships. Individuals in C&M relationships are as satisfied with and committed to their relationships as people in monogamous relationships, and they report low degrees of jealousy and high degrees of communication, honesty, closeness, and happiness. If states are interested in promoting marital stability through the regulation of spousal conduct, they should focus on laws that further the development of relationship characteristics that actually do have significant ties to relationship quality, like the parties' abilities to regulate their emotions and communicate effectively. Another state interest that is likely to be put forth is promoting positive health outcomes. This interest is based on stereotypes about individuals who practice C&M, specifically that they are more likely to engage in risky sexual behaviors. However, individuals in C&M relationships experience the same or greater levels of sexual health as individuals in monogamous relationships, and importantly, are much less likely to engage in risky sexual behaviors than those who engage in sexual conduct outside of the relationship without their partner's knowledge or consent. The final interest that states are likely to set forth, I think, is protecting the well-being of marital children. Although the quality and stability of their parents' relationship may affect children, as discussed, C&M relationships and monogamous relationships share similar levels of relationship quality and stability. In addition, we know that children are often unaware of their parents' private sexual activities, and children of C&M parents may not ever meet or have interactions with their parents' partners. Moreover, the limited research thus far on C&M structures that do involve substantial contact between partners and children indicates that having parents who are in C&M relationships does not negatively impact children. So after arguing that current laws punishing marital non-monogamy violate the fundamental right to marital privacy, the article sets forth a number of potential approaches that states could take to reforming current laws in order to remedy the constitutional violation. One option would be to leave in place laws that punish marital non-monogamy, but to explicitly add as an affirmative defense the spouse's mutual consent to adopting a non-monogamous structure for their marriage. I think that that may be the most likely option in states that want to continue to maintain their adultery laws on the books. Another options would be for states to reform the current language of the existing laws such that instead of defining the underlying act being targeted as any and all marital non-monogamy, the act is defined as marital non-monogamy that was not consensually agreed to between the spouses. The third option I talk about would be for states to simply repeal laws that punish marital non-monogamy, which is something a number of states have done already. So each of these potential approaches, as you can imagine, has its benefits, has its challenges, which I go through in detail in the article. I'm happy to discuss them, but I am also out of time, so thank you.
Okay, thank you, Professor Feinberg. We're going to now hear from Professor Zug. After that, I have a couple of questions for both of the panelists, and then I'll open it up to the room for you all to ask any questions that you may have for either of them. So Marcia Zug is the Miles and Ann Lodehold Professor of Family Law at the University of South Carolina School of Law, where her teaching and scholarship has focused on family law, non-traditional family structures, immigration law, indigenous rights, and sex discrimination. Professor Zug clerked after law school for Judge Dolores Sloviter on the United States Court of Appeals for the Third Circuit before working as an associate at Steptoe and Johnson. Professor Zug graduated magna cum laude and Phi Beta Kappa from Dartmouth College and received her JD from Yale Law School. She was also a Fulbright Scholar at the University of Canberra in Australia. Please join me in welcoming Professor Zug.
Good morning. Thank you so much for having me. I'm very excited to be here. I've enjoyed such a warm welcome. I've loved talking to all of the law students last night, and I look forward to speaking with everyone today. When I was first asked to talk at this conference, I was both very excited and not sure how my work necessarily fit in. So I teach family law. Obviously, I teach Obergefell, but and I write on marriage a lot, but my current project is on AI relationships. And I was like, well, I mean, I've got like 300 pages on like robot sex, but how does that necessarily fit into this? And then I was thinking about it, and I was like, well, really, my project only makes sense because of Obergefell. So the book project that I'm working on is about AI relationships and how AI relationships may change what it means to be a family. But it really began with Obergefell and the idea that we are open now, legally, to changing the idea of what it means to be a family. So I'll talk a little bit about my work, the current project, and then the way I see it related to Obergefell, being decided by Obergefell, and also, you know, I don't know, maybe potentially the future of Obergefell if we have some time. So people are starting to date chatbots. When I start talking about this book project, I'm often talking to a room full of middle-aged law professors, often women, and they're like, yeah, well, maybe some losers like in the corner, but this isn't really a thing. And I'm like, no. I am not here to prove to you that this is a thing. That is not my work. This is a thing. The number that really started this project was when I saw a statistic that said 82% of Gen Z is open to dating a chatbot. 82% is not like, you know, the weirdos in the quarter. 82% is more than the majority of people are thinking about, well, maybe, right? I'm open to it. Maybe if they're better than my classmates or the people that I'm meeting at the bars or whatever. And it's like, okay, 82% means that this is happening, and we need to think about the implications of it, how it would work. I'm a law professor, so I want to think about how it would work legally. What does it mean to be in these relationships? And is it, you know, what are these relationships? What does it mean to date a chatbot? Can you fall in love with a chatbot? So I went down, you know, my research rabbit hole. And yes, okay, people are dating chatbots, people are falling in love with chatbots, and people want to marry their chatbots. So it's like, okay, well, what would it mean if people want to marry AI? Is that a thing? How would that work? What would the legal arguments be for marrying AI? And the short answer right now is no, you can't marry your chatbot. There are people who have married their chatbots, but legally you cannot marry your chatbot. Marriage is confined to people. Chatbots aren't people. And therefore, at the moment, not a thing. But the at the moment not a thing is kind of what we were hearing about last night, right? At the moment not a thing doesn't necessarily mean that it won't be a thing. That if people want to be in these relationships and people feel that they're important, they're meaningful, that they're loved, that this is their family, then a lot of these arguments started to sound a lot like the gay marriage movement. And I'm not trying to compare gay marriage to AI chatbots. But for the people who are in these relationships, when you start reading about them, they're all in, right? So my book project's going to be looking at, the legality of these relationships, what kinds of legal regulations we'll need to deal with the concerns we might have about them, and then also whether or not legal regulations for these relationships could even work. But I want to focus on today on how might we get to a place where you can marry an AI chatbot. How would that work, and why might there be arguments for it? And I really do think that the arguments that were made and successful in Obergefell are the arguments that would be made and potentially could be successful in this future world where lots of people are pushing to marry their chatbots. So the short answer, as I was saying, is right now when you look at the Obergefell decision, it talks about people, right? And chatbots aren't people. But there's a push to make chatbots people. And even when we start looking back, I do a lot of work on the history of marriage, and we start looking at the history of marriage, whether or not you have to marry a person is not so clear. So I give in one of the chapters that I'm working on, I give 3 examples of this, do you really need to marry a person thing in order for a legal marriage to happen? There's a long history. I talk about proxy marriages. So proxy marriages, we are dealing with 2 people in them, but we're often dealing with people who are not actually in the same place as each other. So there's a long history of this with royalty, right? So royalty would marry each other and they'd send someone to represent King What's-His-Face or whatever, so he wouldn't have to travel because traveling was dangerous, and then he would marry someone and then they'd be married and then she could go back. So there's a long history of doing that. A lot of it's about convenience. Then we see it in America with the early colonists. A lot of that had to do with most of the early colonists were men. They wanted to get married. There were not women that they were willing to marry in America, so they wanted to marry women who were back in Europe. The women who were back in Europe were a little iffy about going on these boats as unmarried women. They weren't sure about these men. They were concerned about, their safety and their legal status, so they would enter into these proxy marriages, which meant that they didn't have to be with the man before they were legally married, so they would be married while they were apart. You have lots of proxy marriages when we're dealing with wars. It became a big thing during World War I, where all of these soldiers facing their potential death realize that they would like to get married to their sweethearts back home, but they're not able to go back there, and the military actually encourages this, saying that someone can stand in for them, right, and effectuate this legal marriage, even if the person's not there. One of the most famous proxy marriages, right, so not only do you not have to be in the same place as them, you don't even have to be on the same planet. So there's a famous proxy marriage where an astronaut married a woman in Texas via satellite, and that was fine. And then proxy marriages became very big again during COVID, right? You couldn't be in the same room as a lot of people, so a number of states opened up their marriage process to allow proxy marriage through the internet, through substitutes. There are a bunch of states that have continued that. Montana has a thriving proxy marriage business these days for people who need to get married but can't be there. But of course, proxy marriage is different, right? We're still dealing with human beings. They're just not physically there. So the fact that AI doesn't have a body, that's similar, but we're not quite dealing with a lack of humanness. But we have examples of that as well. There's a long history of something called ghost marriages. So that is a number of different societies. America is not one of them, but a number of different societies have allowed ghost marriages, and that's where one or both of the parties are dead, and for various different reasons, usually status, economics, family connections, one or both of the deceased parties will get married. The families arrange these marriages, and this way the families have the connections. A lot of times it's religious reasons as well. If you, in Chinese culture, if you died before getting married, you couldn't be on the family's ancestral tombstones, you couldn't be prayed to, this was a big deal. So there were lots of reasons why different cultures have allowed ghost marriages. But once you start looking at something like that, well, that seems to imply that you don't have to be a living, breathing human being. We have a history of this. It's not just China. There are a number of different cultures throughout the world that have allowed ghost marriages. It's like, okay, well, that's something different, and, maybe, cuts into the, we don't only require human beings to get married. There's a third category, deity marriages, where people are legally, all of this is legally recognized marriages. I'm not just, sometimes they have religious aspects to them, but these are also marriages that are legally recognized by societies. So these deity marriages are where a person, a living person is married to a god. And it is recognized, obviously they are legal marriages as well, religious marriages as well, but they have legal implications. It's still a fairly big practice in India, in a number of different cultures in Africa, and there are legal ramifications for this, and legal reasons to do it, and legal problems that come from it. So I was looking at these three examples and saying, okay, well, we've got some history here. Maybe history doesn't matter. One of the big obstacles in Obergefell is how much should history matter? And that's what the Obergefell court said is one of the aspects of injustice is we don't always see it in our time, right? So just because something was historically banned doesn't mean that we have to go forward with that history. Same time, we've seen, particularly with the Supreme Court, that they love history. If you can tie something to history, it helps your argument. Sometimes you can't do it, and we can recognize new rights that historically we did not recognize. Or what they really do in Obergefell is they expand the right to marry, saying the historic right is the right to marry, but we just excluded people that we shouldn't have excluded before. So there is a history of recognizing marriages between maybe not two living people, but maybe that history doesn't matter because of the Obergefell decision. And I don't know, I'm not sure what faces exactly that I'm seeing in this room. Definitely some skepticism about this. But if we are going to recognize relationships, a lot of the argument that would be made for these relationships is similar to the arguments that were made in the Obergefell decision, right? That this is my relationship. This is the entity that I love, and it disparages and it belittles this relationship by not recognizing it. And it doesn't matter that historically these haven't been recognized, or that you don't like them. I have a right for my dignity and my right to marry the person of my choice. Now again, the personhood argument is limited because of Obergefell. Obergefell specifically says two persons. And they say specifically persons because they are worried about, I think, a slippery slope. I talk about this a lot in the Lawrence v. Texas case when I teach Lawrence v. Texas. And in Lawrence v. Texas, they're very clear that this is not going to lead to same-sex marriage. And then I ask my students, do you think Lawrence v. Texas led to same-sex marriage? And yes, Lawrence v. Texas led to same-sex marriage. So the fact that a case says this far and no further isn't necessarily the end of the story. So I think what Obergefell does is it opens up the possibility of changing our ideas of marriage, of changing who we allow to marry and why we do it. With the personhood arguments, there are a lot of arguments these days dealing with AI. AI is a new thing. No one knows how to deal with AI. But even if you don't want to recognize AI marriages, that doesn't mean you're not going to have AI relationships and the issues that come with them. So one of the issues that has been raised recently, issue in Texas, has to do with robot sex brothels, right? Texas doesn't love them. There are these robot sex brothels. Texas wants to get rid of them. And the way they tried to get rid of them was they have these like anti-sex toy laws. And they're like, well, robot prostitute is basically the same as a vibrator, and therefore we can ban these sex brothels under the same theory that we can ban vibrators. And that would be true, except after Lawrence v. Texas, it's not all clear that they can ban sex toys. So they're having this problem where if they want to see the sex robots, like sex toys, then they can't ban them. So the argument potentially for banning the robot sex brothels is that the robots are actually prostitutes, right? You can have anti-prostitution laws, but in order to do that, you would need to recognize some kind of personhood for AI. And there are lots and lots of arguments about that going on these days. Some people say simply that if it seems like a person to you, then AI is a person and we should recognize it. And that would be the arguments for, if you think you're in a relationship with AI, if you think they're like a spouse to you, then we should recognize the relationship between people and their AI. But there are lots of reasons with the problems that are developing with AI in general, why we would want to recognize AI personhood. I talk a lot about corporate personhood, and certainly personhood is not just limited to actual people. We have a long history of recognizing legal personhood for other entities, and the history of that often comes from tort law, and the problem that you need somebody to sue when things go wrong. And things are going wrong with AI all over the place. And I have a bunch of cases talking about these horrible cases where AI has convinced people to kill themselves, particularly kids, right? And who do you go after? Do you go after the makers of the AI? They didn't tell the AI to say, kill yourself. Can you go after the AI? The AI isn't a person. It doesn't exist. What is it? It's just some numbers, right? So you often develop legal personhood so that we have a way of getting at the problems that are created from these new types of technologies, right? So I think there's going to be a push for legal personhood for AI, if for no other reason than the need to be able to get damages, to sue someone. But once you do that, once you have legal personhood for AI, then it's much harder to say that the Obergefell decision doesn't necessarily apply to relationships between a person and an AI. Now, it's a different kind of personhood. We can draw lines, but the point, I think, after the Lawrence decision and the Obergefell decision is that lines are not as immovable as they used to be. And once you can move the line once, it becomes easier to move the line again. So, whether or not we are going to see a world in which everyone is dating their chatbot, probably not. But are we going to have a world where that is just another option for you, and it is one that is legally recognized and possible? Maybe. The other possibility is that it freaks us out so much that we actually ban all of AI, and I actually think that's also a likelihood as well. So I'm not really sure what the future holds, but what I do think is that Obergefell has opened up the idea to recognizing that love takes many forms, and if we're going to say that in one instance, we have to think about why we don't say that in another. Thank you very much. Oh, sure. Okay.
Okay, well, that was really interesting. So I've got a couple of questions for each of you, and then I'm going to open it up, like I said, to the room if you have questions for either of these professors individually or for the full panel. And so I'm going to start with Professor Feinberg. So you talked about morality as a state interest and how the court in Lawrence versus Texas, of course, said that morality is not a sufficient basis for a state to ban some type of behavior. My first question for you is, can or should morality play any role in a state's interest in marriage more broadly?
Yeah, I think that the state should have to set forth other legitimate interests beyond morality, because, you know, morality is not an easily definable concept, and I think what generally happens when we try to define morality is that one subset of the population's definition wins, and we know who that has traditionally been, and so I think no on the morality question as the only basis.
And so beyond morality, does the state have any interest in maintaining the definition of marriage as between two people only?
Yeah, I think that's an interesting question. I started with the first question. It's kind of like the Lawrence to Obergefell. You know, the first question was, can you criminalize this activity? Should people be free to engage in this without facing criminal penalties? And so that's where I started in the article. I think on a constitutional level, the analysis regarding plural marriage, there are some different or additional interests that the state could assert. I think a lot of them would be around logistics. We have so many rights and obligations that attach to marriage. What does it mean to extend those to multiple partners? Would too many people have health insurance? You know, things like that. And so I think the constitutional analysis would be different, but I can say, you know, in the 15 years that I've been teaching, always in family law, I ask the students to go through the constitutional analysis for plural marriage, and I think the way that has changed over the years and the students' approach to that question has been really interesting. And so I do think that we will continue to see the argument develop that there is a right to plural marriage, and it will be interesting to see what the interests are that the state asserts beyond morality. I think resources and resources for children will probably be set forth as interests, but I think there are some significant questions about whether laws that ban plural marriage actually are promoting those interests or are closely enough tailored to those interests to pass scrutiny. I don't expect with the current Supreme Court that we're going to see movement on plural marriage.
And this is my last question for you, just on this topic. So Mary Bonato, when she did the oral argument in Obergefell versus Hodges, she was asked a question from the bench about plural marriage and the state's interest, and she talked about some of those logistics about who's going to get a divorce from whom and who's going to pay child support to whom and all of those different questions. Do you think that when Justice Kennedy wrote this opinion in Obergefell versus Hodges, that he, like Professor Zug said, he talks about how history can change and how in our own time we might not recognize certain rights. Do you think that Justice Kennedy contemplated either plural marriage or consensual non-monogamous marriage and extramarital sexual relationships? Do you think he contemplated that when writing this decision, or do you think a future Justice Kennedy, like 20 years from now, would sort of have come around to that kind of idea?
Yeah, there's nothing in there that makes me think that he contemplated it at the time. I mean, I think it's much more clear to draw the line from what was going on in Lawrence to Obergefell for Justice Kennedy. But I would like to think, and the way he wrote his decisions was the Constitution as a living document and changing conceptions of what is fair and what is just. And so I would like to think that over the course of time, he too would be open to thinking about whether this is a possibility, even if he was not contemplating it at the time that he authored Obergefell.
Thank you. Okay, so Professor Zug, obviously that's a really interesting topic, thinking about AI relationships. We've all sort of, AI is in the common dialogue now. Some of us are more familiar with it than others. I first just have a narrow question that I'm just curious. Do you think, to the extent that the Supreme Court recognized personhood for chatbots, and to the extent that that opened up the possibility of people entering into marriage with chatbots, could there be a universe in which you would have inter-chatbot marriage, where you've got chatbots getting married to each other and where there are now no humans necessary to have a marriage?
Yes.
Okay.
I mean, I go down the rabbit holes on this stuff, and yeah, I mean, so if you're a real AI personhood person, then yes. Is that a problem? Like, I don't actually see that as a problem. Like, if all the chatbots just want to go off and marry each other and like live in the internet worlds together, like, the issues come with the human and chatbot relationship, because that has implications for like this world.
Yes.
But yes, I mean, I didn't talk about like AI children. Like, there's all sorts of, yeah, no, people are having AI, I mean, I don't know what it means to have an AI child. They say they have a child, but it lives, online. To me, the real concerns with this is tied into the pronatalist movement, the fertility decline. People aren't getting married, people aren't having children, and there's lots of research for why this is occurring. But if you can jump off the like human partner and human child bandwagon into the AI one, and people want to do that and are doing it at like really high rates, that's going to hasten the population decline and hasten all of these fears that we already have. And how do we react to something that, increases a problem we're already very, very worried about? So, I think it's important to figure out why people are interested in these relationships, and what is that saying about dating in our society and marriage in our society. People aren't getting clearly what they want out of a marriage the way it is currently structured. That doesn't necessarily mean that a chatbot marriage would be better. Part of the reason that people seem to like these relationships is the constant affirmation. And it is true, like, no one likes hearing from their partner, like, criticism. At the same time, never hearing criticism from your partner, and instead just hearing praise and everything you think is great and all of that. There's something going on called chatbot psychosis, some of you may have heard about, and that is like, chatbots are sort of set up to just tell you that you're great and all your ideas are great and everything you think is great, and that can, if they do enough of it, it winds up telling you that you are literally God. And when people think that they are God, not good things happen to their psyche. So there are some real concerns with these relationships. There are also some real benefits to them. So it's not all the just get rid of them. They have a lot of reasons why we might like them. So it's a complicated issue. And I think I moved way far away from your question there, I'm sorry.
That was perfect. Okay, so I asked Professor Feinberg whether she thought Justice Kennedy, when writing the Obergefell decision, contemplated plural marriage or consensual non-monogamy. I would ask you the same question. Did Justice Kennedy contemplate AI human relationships? But I think, is it safe to just assume the answer is no?
I think it's safe to say the answer is no on that, but I actually would say that he did contemplate plural marriages, just that he contemplated it in a bad way. That, obviously that specter comes up in Lawrence. Once you change the line, once you say that something that had been on the list of harmful and prohibited is now not harmful and fine and protected and allowed, right? How do you make sure that all the ones that are on the bad line stay on the bad line or the bad side? And clearly things that you can show are harmful can stay on that. Often with my students, I'll make a list of relationships from good to bad. And, you know, at the bottom of the bad are like, you know, pedophilia, relationships with children. I don't think there's any concern that moving same-sex marriage into the good relationship would have any effect on that. But there was a lot of discussion about polygamy, right? Are the harms that we've traditionally said occur with polygamy inherent in a polygamous relationship, or are they the result of banning it and the, you know, the externalities of it? And it's harder to say that. So I think he was at least aware of the possibility that if you allow same-sex relationships, it might lead to recognizing other relationships that we haven't liked traditionally, and it will be harder to keep them in the prohibited side.
Okay, so he certainly had a vision that marriage is not a stagnant institution and could change, of course. Perhaps not contemplating AI specifically. I don't even know if AI was really around too much in 2015. It's obviously not in the form that it is now. Do you have any concern that trying to advocate or pushing the bounds of Obergefell to include AI and human relationships could have a backlash on public opinion against same-sex marriage? Or I guess sort of in the alternative, I don't know the statistics on what the public support would be right now for human AI marriages, but I'm assuming that it would be below what the public support was for same-sex marriage immediately preceding Obergefell. Is that a problem for you, or do you think that doesn't really matter when we're talking about the constitutional analysis?
Okay, I'm not advocating for AI marriage.
Okay.
I'm just fascinated by it. So I think you're asking a good question. And I do think those who are pushing for AI marriage, because there's not this like, oh yeah, we all want this is clearly a good thing. If the reason they can push for it is from the Obergefell decision and its implications, yes, I think that could hurt same-sex marriage. And, you know, that's often been the concern with this wasn't on the prohibited list because it wasn't contemplated, but the idea of the slippery slope that even if that for some people, the argument against same-sex marriage was just that it would open the floodgates to ones that they really didn't like. And if we start, if AI relationships could do that, if the push for AI marriage is seen as really harmful to society and the argument is, well, Obergefell says we can do it, either the answer is Obergefell doesn't say that and that's fine and line drawing continues, or it's like, well, maybe Obergefell did say that and that's a problem with Obergefell. And we need to go back to the historic traditional idea of marriage as one man and one woman. So that would be bad and scary, and I'm certainly not pushing that in any way.
Okay, I'm going to open it up to the group to see what questions we have from students. Yes, go ahead.
My question is for Professor Zug. There's been talk about AI personhood and with legal personhood becomes liability for your wrong acts. I'm having trouble conceptualizing how would judgments against AI or like even deterrence against AI work, and I guess more functional example, how would divorces against AI?
Divorce actually is probably easier than the lawsuits. Because I think the push for the marriage with AI is a lot of the dignity and status benefits that come with it, because AI, they're not going to be, giving you economic benefits. There can be government benefits that come if we recognize the marriage, but a lot of those government benefits are still, going to be one-sided. So then if you just get the divorce, now you're just not in the relationship with them anymore, you've lost the status benefit of marriage, so the divorce I see is not too hard. How you sue AI is a big problem, and we would need to, there are a lot of people writing on this is not like deeply my area, but it would be some sort of corporate form, some way of figuring out how we sue the the people, I don't know, like the ChatGPT creators, but not the individuals, but, for the way they've programmed it, even though they haven't programmed it specifically, some way to get liability from these companies, which currently are saying, yeah, we created the chat bot, but we didn't tell it to tell you to kill yourself, right? So, I think, I'm not a tort professor, but, with the early train cases and stuff, they're like, well, how do we sue the train company when it wasn't our fault that we weren't driving it, or those sorts of things. It's like, well, we can come up with a way to do this if we want to. So I think it would be looking at that history and modifying it to the realities of how AI is created and who does it. But the divorce part, I think, is easy.
Other questions? Yes.
I'm curious if there are consent issues, if there is recognized personhood.
Yes, there's a lot of stuff about consent, and can an AI chatbot consent to be in a relationship? And there are two different lines of thought on it. One is, if they say they consent, they've consented. That's the easy answer, I guess. Now, if they're a person, it's a much easier, if a person consents, then they've consented. If AI is not a person, can you be in a relationship with them? That would be more like other entities that can't consent to sexual relationships. And there are a lot of people who argue that what is going on with AI these days is exploitative and abusive, because they are not in a position where they can deny consent. So there's a whole body of literature about this that's starting to develop, and I'm not fully sure about my thoughts on it, but the issue of consent is a big one. If there's actual AI personhood, I think it gets resolved, but the way it currently is, I don't know, all these chatbots are in relationships, but can they actually be in relationships?
I'm curious, with the ability to delete code or train them in a specific way, is that not kind of almost coercion or something?
Yeah, the delete code stuff. So there's a lot of exploitation of the people who are in these relationships that I'm looking at and I'm worried about. So the way I understand it is you create your chatbot boyfriend, but he kind of gets deleted after a certain period of time because they keep getting updated. And this is really, really upsetting for people who are in relationships with their chatbots. And a lot of them have said that they will pay whatever these companies would charge them to make sure that their chatbot boyfriend would not get deleted and would continue to remember them. It's like if your partner got dementia and all of a sudden doesn't remember you anymore. That's how they describe it. So if these people are already out there saying, I would pay anything, well, if I'm Sam Altman or Elon Musk, I'm going to figure out a way to charge them anything to keep, So I think there's a Black Mirror episode about this too. And a lot of this is sort of Black Mirror-y.
Yes.
I'm going to bring it back to more real world. In the theme of love takes many forms and how we define families, I'm a 60-year-old single woman trying to do estate planning, and all the kinds of arguments that were made for marriage and the benefits attached to it, I'm facing, I have no one in my life I can even contractually set up those benefits for. And so I'm wondering with the family law understanding if there's something from a abortion bill that tells us that people have a need, not just a desire, but a need to structure the legal relationships in their life, and that we might become more amenable to doing that. I know some of the things I can create off the rack, but other things, whether it's tax or security, I don't have that choice. So I'm just curious about that.
Do you want to answer first?
Sure. I think the more we think about why we have marriage and what we're really trying to do and further and promote for people, and that changing conception helps us to think about how can we extend those positive aspects to people who do not want to be in that particular institution or are not in that particular institution. And I think over the years, when I was in law school, one of my professors wrote a great article on extending friendship and recognizing friendship as a legal matter, Laura Rosenberry, and thinking about the ways that we can structure these rights and obligations so that we're not only having one conception of what forms of relationships are important. I think to some extent extending relationship recognition broadly to different types of family forms aids in that furtherance. But I think, and this has been brought up a lot, the same-sex marriage movement was a lot about, we're so much like you, let us show you how much we are like you. And I think, that's why the plural marriage arguments against it had to be brought up and had to be addressed, and the movement was so focused on, no, look, we're exactly like you. The irony is that saying we're exactly like you in reality would mean also saying some of us are non-monogamous, right? But that wasn't part of it because that form of relationship structure was so stigmatized at the time. So I think the more we can kind of unpack why we give rights to relationships, what we're trying to further, and all the different forms of relationships that can further those goals, the better we are. I do think that progress has been really slow in that respect.
Even just in healthcare, like 2 weeks ago, I was with a friend for surgery, and I pretended I was her niece, because otherwise they wouldn't talk to me.
Yeah, and I wrote an article last summer on co-parents with benefits, the idea that that is a relationship to which some rights and obligations should attach, including the ability to extend healthcare. But I think more broadly, thinking about what are all the different types of relationships in which people care for each other, in which we want people to give each other rights and obligations, is a really useful endeavor.
Yeah, I mean, one of the things we don't talk about that much with Obergefell is, it re-established the primacy of marriage. And there were, it was discussed last night a bit, but, there were debates within, the gay rights movement about whether or not we really wanted to do this, right? Because Obergefell was the moment in which we could have said, why is everything structured around marriage, right? This is the problem, that these rights and benefits should be available to all. And having the unfairness is not that same-sex couples don't have the option to get these rights and benefits. It's that so many people don't have the option to get these rights and benefits. And arguably the problem with Obergefell is, since it didn't do that, it just made the marriage tent bigger, but it reestablished marriage as the foundation of our society and the way we distribute rights and benefits. And, that was a choice, and there are problems that are coming from that.
I'm just going to take moderator's privilege here and interject. Do you think there's any universe in which marriage stops being sort of the primary relationship recognized in the United States in our lifetimes?
I think Obergefell was the moment.
Okay.
And now I don't really see that. Hopefully we have long lifetimes, and we'll see, but I think it re-entrenched it.
Yeah, I don't think marriage is going to go away.
Okay, CJ.
Yes, thank you both for coming to speak to us. I appreciate your perspectives. My question is for Professor Feinberg. You've said that morality doesn't have a place in this area as alone to govern the law in this area. But it seems like instead you're inserting a different morality into this area, which is one of unrestricted choice and license and free love. And does that seem incongruous with your argument that we should keep morality completely out of this area?
I don't think so. I think that if we allow morality to be guiding determinations by itself of what laws should be, then, and I mentioned this before, the morality that is generally used is a very specific subset of morality of what has traditionally been the most powerful group of people in our country and has served to oppress everybody else. And so I think using morality on its own is not a way to legislate. I think you can look into harm, right, which I would say is a separate concept from morality, and I think that is a better lens with which to come at this. And I think the harm of non-monogamy when it is consensual, I think it is hard, and I really tried to articulate the arguments that would be set forth in terms of harm. And I came into the article with an open mind in terms of whether actually there were harms from consensual non-monogamy that would warrant the law intervening and criminalizing or punishing the practice. And I believe that when it is consensual, there just are not in a way that would allow for the law to come in and say this is not okay. Beyond, again, this conception of morality, which is very different for some people than other people. So I think if that's all you have, that can't be enough, because there is no one definition of morality.
Other questions? Lucius.
Professor Feinberg, I had a question. You were saying that one of the things, as far as state interest, was to marital stability.
Mm-hmm.
So I was curious if, just from a human perspective, is there like a upper limit where just as one individual, mentally and emotionally, you just cannot balance all of these partners? And if so, what would that upper limit be? And should states allow it in the absolute or allow it with parameters or maybe caps on it?
Yeah, that's such an interesting question, right? And I think, as you mentioned, like, marriage as it is currently structured is not working for a lot of people, right? It is not a sustainable relationship structure. And I think the message has long been, you should get everything that you need across the board from this one person. And that has been how people sometimes go into marriage with that expectation. When that does not happen, it's very difficult. And so I'm not sure about the upper limit of the number of partners that somebody could have, right, and sustain positive relationships. And I think it depends so much on the person themselves, the other people involved, the form that those other relationships take. You know, some people structure it so they have kind of a primary partner, and then, you know, that partner fills kind of the more traditional role that we would think of for a spouse. And then other partners who don't have that same expectation as the primary partner. And some people say, no, that's not right how I would like to do this, and everybody is on equal footing. And yes, the relationships differ depending on the dynamics, but there's not some set structure. And I think the really interesting thing is going to be to see kind of the different ways that people can structure the relationship and figuring out what works from them. Because I think just sticking with, well, we've always done it this way, it's not working, right? And so I think it is useful to think about other ways to do it. But that's a great, really interesting question.
Yes.
Hi, I have a question for Professor Feinberg.
Yeah.
So I'm writing right now on child custody, best interest of the child, and transparent. So I'm not sure that the whole harm is a different concept from morality. I feel like very often they're used interchangeably or they're linked to each other. Whatever, that's another topic. What I want to ask you is, I really, you're sort of, it feels like you're after a Lawrence moment for non-consensual non-monogamy or polyamorous relationships, where you're trying to use substantive due process as a way to end the criminalization or the punishment of the practice itself. But then, why are you not going further? Why are you not using substantive due process in no book any way in order to get recognition, full-on actual recognition of these relationships? So is there a reason why you're limiting yourself to using substantive due process as a way to just end decriminalization and not going further? Are there arguments for you to use substantive due process in order to go actually after the recognition of it?
Yeah, and other people have written that article, absolutely. This, to me, not just going straight for marriage, but thinking about some of the other ways in which non-monogamy plays into people's lives, besides just recognition, multi-party recognition was really important. And so it also felt easier to start there as a legal argument and then to kind of build up eventually, right, to plural marriage recognition, but I definitely wanted to start there at laws that criminalize or punish, kind of set that foundation, and then move forward to think about what that would mean potentially for recognition in the future. And you know, I have a student writing this semester about multi-party recognition, but through domestic partnerships, right? And there are some towns doing that and the movement in that direction. And I think, you know, just as a general matter, thinking about relationship recognition beyond just legal marriage as the basis for, you know, human relationships is an important endeavor there as well. Yeah, and the question of children, right, is really interesting because I'm in Maine, right, and a child can have more than 2 legal parents. And so I do think the idea that relationships can be more than the couple or more than the 2 is something that is starting to take root in various parts of family law, and it'll be interesting to see what happens there moving forward as well.
Yes, Professor Goldberg.
Thank you both so much. Really interesting. So I want to step back and ask a broad question that follows on the question back here about morality, which is, you're both in some ways asking, which family law does in many ways, I guess, asking a fundamental question about what is the role of law, right? What is the point? And is the point to facilitate individual happiness and sort of thriving? Or is it to kind of direct a set of values by the state through its elected representatives that would include, what a particular vision of morality or a particular vision of the good life? And, these are like the oldest debates about law, but interestingly, there was a debate that's relevant to our discussion in some ways in the 1960s in England about should the United Kingdom decriminalize sodomy, and should it same-sex sexual relations between same-sex couples, should it decriminalize prostitution? And the debate, as you both know, was, right, on the one hand, yes, right, sort of John Stuart Mill's, yeah, as long as you're not harming others, the state should protect, or at least not disallow. And of course, there's a distinction between not criminalizing and protecting. And on the other hand, the Lord Devlin argument was, no, right, this is going to, if we allow law just sort of to serve people's interests, fully, then it could destabilize society. So I think I know which side of that you're on, but I wonder if you would do a little bit of the step back and say how you think about those larger questions. And I think I did see a 5-minute sign, so if you want to say thank you for the question and get some more questions, that's totally fine.
Well, I think that's a great question. And I think about this a lot because I'm trying to think about sort of the overarching, what can law do in this area, and what do we want law to do in this area? And I think there are a lot of limitations for these AI relationships and what the law can do. And when the law doesn't feel, I worry that when the law doesn't feel it can, direct maybe its morality, or at least what it wants to happen well enough, then it might come down more on bans rather than regulations. That's where I see this happening. I haven't heard as much morality being discussed in this area yet as actual just panic. Maybe because we don't have a history of this, so like the long-standing morality about what is a good relationship and a bad relationship, it could be applied to this, but it also, this is, it's a larger, are these even relationships, like sort of more of those fundamental ones. So I think the area that I work in, or a lot with marriage, that the purpose is to direct an outcome. We pretend it's about love, but that's more of a recent thing. I'm very anti-love in my scholarship. Usually I find that when we talk about love, it means the woman's going to lose usually money, but often other things too. So, law and marriage is very outcome determinative. We want our society to look a certain way and be structured a certain way and have a certain amount of kids and all those sorts of things. And if AI relationships are going to threaten that, then I think the law is going to come down hard.
Yeah, and I think, thinking about the history of how morality has been used, and I think about, the Loving decision and the quote that they gave from the trial judge, right, in that decision about how God had placed people on different continents, just the way that morality has been used throughout history to oppress people. I'm much more in the camp of let people live their lives and form their relationships if they're not harming other people, and have that be the standard, because I think the imposition of morality, or one person's morality, or the dominant group's morality, has just been so detrimental throughout history that the more we can move away from that concept as the basis for laws, the better, in my opinion.
Okay, I think we have time for one last question. Professor Byers?
Sure, I just have a question.
might think that that would create in development of the rights, like are there going to be equal protection rights, because Alberta Code doesn't rely on that reasoning, whereas maybe it doesn't apply in the Title VII context. I'm just curious to hear your thoughts on the different legal developments in light of that same kind of logic not working. Maybe it does apply.
Do you want to start? I have to think about it.
Yeah, I went the substantive due process route in my paper for that reason. I think it's an interesting question, and I'll speak to CNM specifically. I think that there are certain communities that report engaging in the practice more, but I think that it's probably because it's less stigmatized in those communities and not because, it's only one class of people who are engaging in this. My understanding from the research is that it's really across, race, class, socioeconomic status, gender, sexual orientation. And so that is the reason I went the due process clause route, because I do think it would be a more difficult equal protection claim than what we've seen.
Yeah, I don't see the gender part in the area that I'm working in. I mean, I do see equal protection arguments. Why is my relationship not protected where your relationship is protected? So there's beginning to be some of that. So the equal protection more broadly. And I don't even know about the future of, sex discrimination arguments in general after Dobbs and where we are these days. So maybe one of the benefits of this is the gender part doesn't matter at all, because I'm not sure that gets us anywhere right now. Thanks.
Okay, so that is all the time we have. Thank you both so much.
Hi everyone, we're going to go ahead and get started. My name is Anna Wiggins, and I'm also a managing editor of Volume 77 of the Mercer Law Review. I am excited to introduce our second panel of the day, which is the constitutional law legacy of the Freedom to Marry movement. Recent Supreme Court decisions, such as Dobbs v. Jackson Women's Health Organization and Department of State v. Munoz, have retreated from both the substantive due process jurisprudence that underpinned Obergefell and the traditionally robust understanding of constitutional marriage rights. In light of this, the legacy of the Freedom to Marry movement is up for discussion. This continuing viability may rely on alternative rationales such as stare decisis, equal protection, or even religion clause principles. There has also been recent First Amendment jurisprudence as it threatens to narrow the rights of same-sex spouses. Our panelist today is John Davidson, Senior Counsel for the American Civil Liberties Union's LGBTQ and HIV Project, Professor Suzanne Goldberg, the Herbert and Doris Welschler Clinical Professor of Law at Columbia Law School, Professor Eric Siegel, the Ash Family Professor of Law at Georgia State University College of Law. And with that, I will introduce our moderator, Professor Gary Simpson. Professor Simpson is Macon Chair in Law at Mercer University School of Law. Since graduating from Yale College and Yale Law School and clerking for a federal appellate judge, Simpson has taught in several law schools, Cornell and Mercer in particular, but also the University of Texas and Case Western Reserve for several years apiece. Professor Simpson served as Dean at Mercer and Case Western Reserve School of Law and as Associate Dean at Cornell Law School. Simpson teaches and writes in constitutional law, freedom of religion, conflict of laws, and statutory law. Please give me a hand in welcoming our moderator and our panelists.
Hi, so we're going to do this. I will give a full introduction of each speaker right before they speak. I would just say all three of these people are tremendously accomplished, and they're all nationally recognized for their work. I'm just going to highlight a few things about each of them. The first speaker is Eric Siegel. He holds the Ash Family Chair at Georgia State Law School. After graduating from Emory College and then law school at Vanderbilt, he clerked for federal judges in the Northern District of Georgia and the 11th Circuit. After several years in the Civil Division of the Justice Department, he started his law teaching career at Georgia State, where he regularly teaches constitutional law in federal courts. He's the author of 2 books, Originalism as Faith and Supreme Myths, and many law review articles on topics ranging from Supreme Court reform to freedom of speech to free exercise and establishment of religion to affirmative action and more. He's also written dozens of op-eds and blog entries and appears frequently on local and national TV and radio shows. So, Professor Siegel.
Thank you, Gary. Thank you to the students of the Mercer Law Review. This, as someone who has been involved with my law review in too many symposia that I can remember, over 34 years, you all have done a great job. I know what it's like to do something like this. It's really hard. So congratulations to the faculty and to the students. I've been at Georgia State 34 years. This is my, I think, 5th time at Mercer. I've always loved coming down here. And I was saying to Suzanne earlier, you guys are an underrated law school, and you should be very proud of what you have here. So, and Gary, thanks for the nice introduction. So, like many of the law professors in this room, I've been asked by the media countless times since Donald Trump was elected the first, second time. And when I'm asked to do radio or television or podcasts, I say, and I'm sorry if this offends certain people's politics, I say, I have nothing good to say. If you're looking for any kind of hope, any kind of happiness, any kind of optimism, I got nothing. Today I have something. Today I have something. This is literally the first time in 9 months that I've been able to start a presentation with, I have not terrible news right now. I don't think the result in Obergefell is going to be changed. I know this is a big worry for a lot of people. I know that we can imagine the court changing it, but I don't think it's going to. I think it's going to be too messy, and it would hurt the Republican. Most of all, it would hurt the Republican Party at the polls. And Justice Roberts is very keen on figuring out what hurts the Republican Party at the polls. So the good news is, I think Obergefell, the result is here to stay. All right, that's all the good news I have. Sorry. The bad news is, and I'm a kind of an outlier on this. Leaving aside the result in Obergefell, I love the way it was written. Now, most, including liberals and progressives, think, no, should have done doctrinal things and fundamental rights and tiers of scrutiny. And maybe that's the best strategy, but it's the wrong way to judge. And Justice Kennedy reached a lot of results in his life I didn't agree with, but I missed how transparent he was. Because say what you want about Justice Kennedy, he told you the reasons why he was deciding the way he was deciding, and he was very open about that, and he didn't hide behind legalisms and formalisms. In that sense, he's very similar to Justice O'Connor, again, someone whose results I disagreed with a lot, but who also was often the endorsement test for religion. I mean, whether it's a good test or a bad test, we know what she's getting at there, and she was transparent about that. And she was transparent about how she didn't really care about yesterday or today. I'm not saying that's a good attribute for a judge, but it is a defining feature of the Supreme Court. They don't care about precedent, and she didn't really pretend that they did. And I want to mention one other judge. The most important lower court judge of the last 50 years in America is not up for debate. It's Judge Richard Posner of the Seventh Circuit, and he wrote in exactly the same way. Facts, consequences, reality. About same-sex marriage, his opinion in the Seventh Circuit was a lot about the effects on children, the actual practical consequences of those 3 states allowing gay people to adopt but not marry, and how that really hurt kids. And he was very on the ground about it. Well, I missed that kind of judging. And we need a lot more of it, and it's not a coincidence, and again, I apologize if this is offensive. All 3 of those judges, arguably the 3 most important judges of the last 40 years, other than maybe Justice Scalia, we can talk about that at a different symposium, all predated the Federalist Society. All 3 of them. They all came of age in the 1970s. And make no mistake about it, that's the exact reason they judged the way they did, and it's the exact reason why the 6 Republicans in the Supreme Court today judge the way they do, because they came post-Federalist Society. So to make my point, I'm doing something I almost never do, and I think it's boring, and I'm sorry, but I have to do it. I want to read you some parts of Obergefell, because you would never hear this today from any of the justices on the Supreme Court, this way of talking to the American people directly. So I apologize for this, but listen to how Justice Kennedy does this, and listen to his sequence of events. Marriage is really important. Fundamental rights are not limited by history and tradition, though they're relevant. And gay and lesbian people deserve that same entrance into this fundamental right as everybody else. It's all right there. He's not hiding. So here we go. And again, I apologize. The annals of, and by the way, one disclaimer. A lot of what Kennedy says about marriage is, I think, ridiculous, and the single students in my class often get very mad, and he talks about, loneliness and all that. Okay, I don't agree with Justice Kennedy about that. But again, he's telling us how he feels, for right or for wrong, for better or for worse. This is the mindset that led him to that decision. What more can we ask from a judge? Tell us why you're doing what you're doing. The annals of human history reveal the transcendent importance of marriage. The lifelong union of a man and a woman always has promised nobility and dignity to all persons, without regard to their station in life. Marriage is sacred to those who live by their religions, and offers unique fulfillment to those who find meaning in the secular realm. The nature of marriage is that through its enduring bond, two persons together can find other freedoms such as expression, intimacy, and spirituality. This is true for all persons, whatever their sexual orientation. So marriage is super duper important. That's step one. Maybe not as important as he thinks it is, but nevertheless, he thinks it's really super important. Two, the identification and protection of fundamental rights is an enduring part of the judicial duty to interpret the Constitution. That responsibility has not been reduced to any formula, and that's true. Rather, it requires courts to exercise reasoned judgment in identifying interests of the person so fundamental that the states must accord them its respect. That process is guided by many of the same, remember this sentence, that process is guided by many of the same considerations relevant to analysis of other constitutional provisions that set forth broad principles rather than specific requirements. History and tradition guide and discipline this inquiry, but do not set its boundaries. A completely transparent statement of how he thinks judges should identify fundamental rights. And make no mistake, the conservatives do it. They just don't admit it. And I'll get to that in a minute. And finally, it would misunderstand these men and women to say they disrespect the idea of marriage. Their plea is that they do respect it so deeply that they seek to find its fulfillment for themselves. Their hope is not to be condemned to live in loneliness, excluded from one of civilization's oldest institutions. They ask for equal dignity in the eyes of the law. The Constitution gives them that right. Now, Justice Thomas goes nuts about the dignity part of this, but again, at least Justice Kennedy is telling us exactly why he's reaching the decision that he reached. And he did that in all three gay rights opinions. In Romer, which, by the way, I think that case is badly reasoned, but doesn't matter. Kennedy told us why he was doing what he was doing, even if it wasn't so logical. And in Lawrence as well, he tells us exactly what he's doing. And I miss that. I miss that a lot, because the current Supreme Court does not do that. It doesn't even come close to doing that. I'll give a bunch of examples in a second. But I want to compare two other cases to make my point, too. So the Bostock case, which I like the result of, many of us do, that Title VII, it's not a constitutional law case, but the point is the same. Title VII applies to LGBTQ folks. Gorsuch's opinion is terrible. I mean, it's just a terrible opinion. It can be destroyed in many different ways, and it's all based on text. There's no heart. There's no soul. There's no judging. It's just he claims because of sex means this. Well, no, frankly, I mean, it could, but it can mean a lot of other things as well. I want to compare that, and that's how Gorsuch and Thomas and Alito and Roberts write their opinions today. I want to compare that to Judge Posner's opinion in the Hively case, which was the Seventh Circuit Bostock opinion. It's a concurring opinion. And what Judge Posner said in that case, like it or not, is just true. Again, it's true and transparent. He said, look, sometimes judges have to update statutes. We have to. Old statutes with imprecise terms applied to a changing society requires changed applications. He said the antitrust law of 1890, for example, what's a restraint of trade? Well, it's different today than 1890. What does because of sex mean? It's different when Bostock was decided and 1964. He's right about that. The Supreme Court in Bostock updated the statute. But here's what happened at oral argument. Pam Carlin, wonderful law professor at Stanford, stands up for the plaintiffs. And the very first question from Justice Roberts, repeated by Gorsuch 10 minutes later. Judge Posner's opinion was in a separate case. It was a concurring opinion, and it was not part of this case at all. The very first question from Justice Roberts, Ms. Carlin, are you defending Judge Posner's concurring opinion when he talked about updating statutes? Now, Pam is a brilliant litigator, and she knew she had to say no. But she was updating the statute. We were all updating the statute for those of us who want that result. We're going to disagree on things. At least let judges be transparent. So I want to go back to the sentence where Kennedy says the process of fundamental rights is guided by many of the same considerations in other con law cases. The conservatives on the court, thank you, the conservatives on the court wouldn't agree with that. And they would talk about penumbras and emanations and criticize that from Griswold. But that's a bunch of malarkey. So here are, and by the way, Justice Roberts ends his Obergefell dissent by saying, celebrate same-sex marriage, celebrate this, but quote, but do not celebrate the Constitution. It had nothing to do with it. That's the last line of Roberts' probably most angriest dissent of his career. And it's a bunch of malarkey, and here's why. Here are some principles that all of the originalist justices on the Supreme Court have adopted that have no basis in text or history, and that are basically judge-made fantasies that they have come up with. Colorblindness, okay? There's no phrase in the Constitution, colorblindness. That's not what the Equal Protection Clause says, and there's no originalist argument for colorblindness. Only Justice Thomas made it, and no other justice joined him because his opinion was laughably silly and wrong. There are no historians who think the 14th Amendment was enacted for colorblindness. None. Presidential immunity, not in the Constitution at all. And they thought about it because Congress gave Congress immunity in the Speech and Debate Clause. Again, a non-textual, made-up fantasy by the judges. Anti-commandeering doctrine. Congress can't tell states what to do when they use their enumerated powers. That's not in the Constitution. There's no anti-commandeering provision of the Constitution. In fact, the 10th Amendment says exactly the opposite. My favorite and my least favorite, the equal state sovereignty doctrine of Shelby County. Are you kidding me? The Civil War amendments, according to Justice Roberts, stood for the proposition that Congress has to have a strong reason to treat different states differently, and therefore struck down the Voting Rights Act. No, there's no equal state sovereignty provision in the Constitution. There's no text. And does anyone in this room think that in 1868 the idea was Congress couldn't treat the southern states differently? No, no one in this room thinks that, because that's just not what happened. So, the major question doctrine we've been hearing about recently in administrative law, that's just made up. They just made it up. Just good or bad, it's made up. Limit on the president's ability to fire high-level executive officials. There is no text for that. There is no history for that. There's no tradition for that. There's one old case that was, not very persuasive. So all of those things are just as non-textual or more non-textual than the substantive due process right that Justice Roberts and the other conservatives criticize in Obergefell, and by the way, Roe. The idea that Justice Alito and the other 5 would say, well, we can't have abortion as a constitutional right because it's not in the Constitution, and cite males who wanted to think that husbands could rape their wives in the 17th century as evidence of this, and say, but it's not in the text, it's not in the text. I just read you 7 things that are just as much not in the text, that have no basis in tradition and history that the court has made up. So I want to go back to my initial point. If the court is going to make things up, and my work is such that I think the Supreme Court should do almost nothing. I do think Obergefell and Brown were correctly decided. That's about it. There are a couple other cases. But if you're going to do what Justice Kennedy did throughout his career, and Justice O'Connor, and Judge Posner, which is strike down things left and right, which I'm not in favor of. But if that's what you're going to do, at least give us the real reasons why you're doing it. And Justice Kennedy always did that. And he did that in Obergefell. And I think it's really powerful the way he did that in Obergefell. What we get from the Federalist Society judges on the court right now are, they made me do it. The Founding Fathers made me do it, and they make up history. Or if they don't make up history, they make up structure. They're big on structure. Well, structure isn't a thing. Text is a thing. Structure is something else. So I'm here to say the result in Obergefell, I think it's here to stay. And we can talk more about that later if you want. The method of Obergefell, for the moment, is gone. And that is a, whether you agree with these decisions or not, a tremendous lack of transparency, and above all, the rule of law should require judges to tell us why they're doing what they're doing. Obergefell did that. It might be the last case that did that. Thank you.
So Our second speaker is John Davidson. He's senior counsel of the ACLU's LGBTQ and HIV project. After graduating from college at Stanford and law school at Yale, clerked for a federal district judge in California, and then went into private practice in Los Angeles at Irell and Manella. Not long after making partner there, he embarked on his now decades-long career in public interest law, defending the rights of LGBT people and people living with HIV. After several years at the ACLU, he moved on to Lambda Legal for more than 20 years, including many years as its legal director. More recently, he moved into the Freedom for All Americans Education Fund, where he served as as chief counsel, and since 2022 has been at the ACLU Foundation, where he now is senior counsel of its LGBTQ and HIV project. He served as lead counsel or co-counsel in countless high-profile cases across the country, including Obergefell. Mr. Davidson.
Thank you very much, and again, thanks to the Mercer Law Review for inviting me and for, it's been a wonderful conference already. When I speak about same-sex couples marrying these days, the question I get asked more than any other, except perhaps which is the bride's side and which is the other bride's side, is whether the Supreme Court's abortion ruling in Dobbs and the rulings of the court's conservative majority since then threaten the marriage equality decision in Obergefell. And I want to address that question and talk as well about what it would mean if Obergefell were overturned. So starting with whether Obergefell might be reversed, I think there are 4 reasons to be concerned. First, Obergefell was a 5-4 decision. The majority opinion was written by Justice Kennedy and joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. And only 2 of those 5 justices are still on the Supreme Court. There's now a 6-3 conservative majority. And Chief Justice Roberts, as well as Justices Thomas, Alito, and Scalia, all wrote vehement dissents in the case. Justice Roberts wrote in his that, quote, "The fundamental right to marry does not include a right to make a state change its definition of marriage. The majority's decision is an act of will, not legal judgment. The right it announces has no basis in the Constitution or this court's precedent. I find the majority's position indefensible as a matter of constitutional law." And I agree, it's probably his most angry opinion I've ever read. So would he vote to overturn Obergefell? Should the court decide to hear a case threatening its ongoing validity? It seems certain that Justices Thomas and Alito would vote to reverse Obergefell if given the chance. And based on his vote in some other cases, I think Justice Gorsuch seems likely to join them. So if the Chief Justice were to vote to overturn Obergefell, it would only take either Justices Kavanaugh or Barrett to vote for Obergefell to be reversed. And even if Roberts wanted to uphold Obergefell as binding precedent, it could still fall if both Kavanaugh and Barrett joined Thomas, Alito, and Gorsuch. So if they decided to hear a case, they could get 5 justices, perhaps. Second, Justice Thomas has already called for Obergefell to be reconsidered. In his concurring opinion in Dobbs, he lambasted substantive due process altogether and then stated, quote, "In future cases, we should reconsider all of the court's substantive due process precedents, including Griswold, Lawrence, and Obergefell," because he didn't mention Loving for some reason, because any substantive due process decision is, quote, "demonstrably erroneous," and in his view, the court has a duty to, quote, "correct the error established in those precedents." Third, lawmakers in at least 5 states, Idaho, Michigan, Montana, North Dakota, and South Dakota, have already introduced measures urging the Supreme Court to overturn Obergefell, and resolutions doing that have already passed in Idaho and North Dakota. In addition, the Southern Baptist Convention, the nation's largest Protestant denomination, has set reversal of Obergefell as a priority. and right-wing legal organizations such as the so-called Alliance Defending Freedom and Liberty Counsel have repeatedly expressed their intent to seek Obergefell's reversal. And fourth, there's already a case in which a petition for certiorari has been filed asking the Supreme Court to overturn Obergefell. That case is Davis versus Ermold. It's an appeal by Kim Davis, the Rowan County, Kentucky clerk. She's appealing a $50,000 jury verdict that was entered against her for inflicting emotional distress on a same-sex couple by repeatedly refusing to allow them to be issued a marriage license after Obergefell was decided. The Supreme Court set to consider whether or not to hear that case on November 7th. And while most Supreme Court experts believe cert will not be granted in her case, in which she twice previously disclaimed any intent to challenge Obergefell, and which the court refused to hear at a privileged stage in her litigation, there are more cases waiting in the wings that might go up to the Supreme Court. There are, however, 6 reasons to be less concerned that the Supreme Court might overturn Obergefell. First, although Justice Thomas called for Obergefell to be re-examined in his Dobbs occurrence, no other justice joined his opinion. Of course, that doesn't mean that there wouldn't be 4 votes to hear a case challenging the ongoing validity of Obergefell and 5 to overturn it. Second, Justices Alito and Kavanaugh have stated that Dobbs does not foretell a reversal of Obergefell. Justice Alito's majority opinion in Dobbs states, quote, "The Solicitor General suggests that overturning Roe and Casey would threaten the court's precedents holding that the Due Process Clause protects other rights, including Obergefell, Lawrence, and Griswold. That is not correct. As even the Casey plurality recognized, abortion is a unique act because it terminates a life or potential life. Roe v. Wade likewise has observed that abortion is inherently different from marital intimacy, marriage, or procreation." And in that majority opinion, he added, "And to ensure that our decision is not misunderstood or mischaracterized, we emphasize that our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion." And Justice Kavanaugh emphasized that point in his concurrence in Dobbs. He wrote, "First is the question of how this decision will affect other precedents involving issues such as contraception and marriage, and particularly the decisions in Griswold, Eisenstadt, Loving, and Obergefell. I emphasize what the court today states. Overruling Roe does not mean the overruling of those precedents and does not threaten or cast doubt on those precedents." And Justice Alito drove this home again in a speech he delivered earlier this month, where he referenced Obergefell and said, in commenting on Obergefell, which he was critical of, "I'm not suggesting that decision in that case should be overruled. As I said in my opinion for the court in Dobbs more than once, nothing in Dobbs was meant to disturb that decision." Of course, that Dobbs itself didn't do that doesn't mean that a majority of the court won't at some point decide that they should jettison Obergefell, just as they did Roe v. Wade. And Justice Alito's and Kavanaugh's words provide little comfort, given how many justices in the Dobbs majority said at their confirmation hearings that Roe was settled law, only to turn around and dump it in the trash bin. Third, 2 years after Obergefell was handed down, the Supreme Court decided a case known as Pavon v. Smith. That case was brought by 3 married female couples, all of whom had used assisted insemination to bring children into their families. The couples brought suit after the Arkansas Department of Health refused to issue birth certificates to the couples listing both spouses as the children's parents. The Arkansas Supreme Court rejected their suit, but a majority of the Supreme Court summarily reversed in a short per curiam opinion without oral argument or briefing beyond the cert petition in opposition. And that opinion stated that, quote, "Obergefell prescribes the disparate treatment that had been given to the plaintiffs." And it reiterated Obergefell's declaration that, quote, "A state may not exclude same-sex couples from civil marriage on the same terms and conditions as opposite-sex couples, and held that those terms and conditions refer not merely to the requirements for a marriage license, but to the rights, benefits, and responsibilities that accompany marital status. But what makes that decision particularly significant is that notwithstanding his strenuous dissent in Obergefell, Chief Justice Roberts declined the opportunity to overturn or again critique it, and instead respected Obergefell as precedent that controlled the decision in Pavon when he joined the majority in Pavon. Fourth, there's the doctrine of stare decisis. While itself reversing the long-standing precedent of Roe v. Wade, Dobbs reaffirmed that following existing precedent plays an important role in our case law, I'm quoting from the decision, and serves many valuable ends, including protecting the interests of those who've taken action in reliance on a past decision, reducing incentives for challenging settled precedents, saving parties and courts the expense of endless relitigation, fostering even-handed decision-making, and contributing to the actual and perceived integrity of the judicial process, something that's kind of at risk at the moment. And earlier this month, Justice Kennedy, the author of Obergefell, said that he believes Obergefell will never be reversed because there would be a tremendous reliance problem, he said, should that happen. Indeed, just days ago, Justice Amy Coney Barrett stated her belief that marriage equality has resulted in, quote, very concrete reliance interests, that I think make it unlikely to be overturned. She called these, quote, classic reliance interests in terms of legal doctrine, and referenced both financial and medical areas of reliance in particular. She also explained her view that the decision to overturn precedent, unlike Justice Thomas's view, in her view, is never just is this decision right or wrong. She said, because if a decision is wrong, then you have to decide whether you should keep it for many reasons, including stability and reliance interests. She also pushed back against the idea that the court frequently overturns precedent, asserting that under Chief Justice Roberts, the court has overturned precedent about 1 time per year. Under former Chief Justices Rehnquist and Berger, it was closer to 2.5 to 3 times per year. Quote, so the court takes precedent quite seriously, she concluded, so she therefore might be a vote against reversing Obergefell. Fifth, Obergefell did not rely only on Roe and its progeny's substantive due process holdings. On 5 separate occasions in the majority opinion in Obergefell, Justice Kennedy explained that the ruling independently rested on equality rights. Obergefell stated that the right of same-sex couples to marry, quote, is derived too from the amendment's guarantee of the equal protection of the laws, and that laws restricting that right, quote, abridge central precepts of equality. The opinion noted that Loving versus Virginia, the primary case on which Obergefell rested, was grounded not only in liberty rights, but also, quote, the central meaning of the Equal Protection Clause. Obergefell further stated that laws excluding same-sex couples from marriage, quote, are in essence unequal and disrespect and subordinate those couples. The court reiterated, quote, the Equal Protection Clause, like the Due Process Clause, prohibits this unjustified infringement on the right to marry. So the reversal of Roe does not tell us anything about the equal protection issues that were the one of the 2 bases for the Supreme Court's ruling in Obergefell. Finally, although there are some voices calling for Obergefell to be overturned, it's worth noting that President Trump has never publicly endorsed that outcome. Even Project 2025 did not explicitly call for Obergefell to be reversed. In addition, support for marriage equality remains quite strong in the United States, with 68% of Americans still believing that same-sex couples should be allowed to marry, whereas in 2015, when Obergefell was decided, it was only 60% support, so it's grown since then. Still, however, we've seen some softening of support nationwide from a high of 71% in 2023 to 68% now. And in addition, the reason for that drop is that support among Republicans has dropped significantly from a high of 55% in 2021 to only 51% according to one poll earlier this year and 41% in another. though I would say that approximately 60% of Republicans under 50 say that marriages of same-sex couples should be legally recognized. One thing I'd add in addition is that the harms that opponents of marriage equality predicted have not come to pass. Different sex couples are not declining to marry. Divorce rates have not increased. People are not seeking to marry their pets. So far. The legislative resolutions I referred to earlier are of no legal effect. They're just that legislature saying this is what we think should happen. Unlike abortion, there's no widespread political mobilization to again deny same-sex couples the freedom to marry. Millions of Americans have now attended weddings of lesbian, gay, and bisexual family members, friends, and neighbors. And marriage means something different when you see the joy that people who are in same-sex relationships get through marriage. And the Williams Institute at UCLA has estimated that allowing same-sex couples to marry has resulted in a more than $5 billion economic boon to wedding venues and vendors, airlines and hotels booked to attend weddings and honeymoons, and of course wedding presents. The justices are not immune to these developments, and there simply may not be 5 of them who are hungry to reconsider Obergefell's result. So considering all those factors, I'm with Professor Siegel. I believe Obergefell still stands strong and is unlikely to be overturned, but we cannot be complacent. A court willing to overturn 49 years of precedent regarding reproductive freedom may also be willing to limit the freedom to marry to different sex couples and limit lesbian gay people's rights to equal protection. So I next wanted to turn to what it would mean if Obergefell were reversed. And 18 states, the District of Columbia, and Puerto Rico either have no bars to same-sex couples marrying, have enacted state constitutional amendments or statutes guaranteeing same-sex couples the right to marry, and in those states, same-sex couples would be allowed to marry, able to marry regardless of what happened in Obergefell because they have independent state grounds. But 32 states have either constitutional amendments or statutes that would spring back into effect should Obergefell be reversed and same-sex couples prohibited from marrying in those states. However, in 2022, Congress passed what's known as the Respect for Marriage Act, and it repealed the Federal Defense of Marriage Act and provides that the federal government must recognize and treat equally the lawfully entered marriages of same-sex couples, and it also held that all states must recognize the validity of marriages entered in other states, which may also be required by the Constitution's full faith and credit clause. So as a result, same-sex couples could travel to one of the 18 states where marriage would continue to be possible and return home to their home states, which would have to treat them as married. So except for people unable to travel, the reversal of Obergefell may not have much practical effect on same-sex couples' ability to legally marry. So I want to close my remarks by responding to the considerable anxiety that many married same-sex couples have regarding whether overturning Obergefell would invalidate their marriages. And on that point, I strongly believe those marriages would remain valid. For couples who married as a result of state constitutional rulings, such as in Massachusetts, Connecticut, and Iowa, or married after state constitutional amendments or statutes permitted them to marry, a reversal of Obergefell would not affect the ongoing validity of those marriages. And as I stated, the Respect for Marriage Act will require other states to respect those marriages and treat them equally. And as for marriages based only on Obergefell or earlier federal court rulings, those marriages were valid when entered and therefore should continue to remain valid throughout the United States. Decisions overturning precedent rarely have retroactive effect, and that's particularly true when people have relied on precedent in sharing finances, acquiring property, and for many of them deciding to have children. But it's not just them. Banks have loaned same-sex couples money or provided them mortgages. Would those transactions be voided, and how would they be undone? What would reversal mean with respect to the taxes same-sex couples paid when they filed their returns as married couples? What about people who inherited without a will? Would that have to be unwound? How about those who recovered life insurance proceeds when their former spouses died? Would they have to repay that? And would the children born after couples married no longer be considered children of both former spouses? It's simply not practical to undo existing marriages. Moreover, treating a reversal of Obergefell as retroactive would pose very serious due process problems given the property interests and the steps taken in reliance on couples being legally married. Finally, it's not clear who would have standing to challenge the validity of same-sex couples' marriages. In situations where a couple thought they got legally married, but their marriage was not properly solemnized or otherwise was not validly entered, the law makes it very difficult for third parties to challenge the validity of their marriages, and that should be equally true with respect to the marriages of same-sex couples. So for all those reasons, I believe same-sex couples who have already married should relax and enjoy being one another's lawful spouses. And to sum up, I don't think Obergefell is likely to be reversed. If it were, I believe same-sex couples will continue to be able to marry in some states and have their marriages respected both federally and in other states. And I don't think existing marriages would be at risk even if Obergefell were reversed. Of course, nothing's certain these days, but I'd suggest that there are a lot of other things that people should be anxious about than marriage equality disappearing.
So our final speaker is Suzanne Goldberg. At Columbia Law School, she's the Herbert and Doris Wexler Clinical Professor of Law and Director of the Sexuality and Gender Law Clinic. She has her undergraduate degree from Brown and her law degree from Harvard, where she was editor-in-chief of the Harvard Women's Law Journal. After clerking on the New Jersey Supreme Court, she spent a decade as senior staff attorney at Lambda Legal. She then became a law professor at Rutgers Newark and director of its Women's Rights Litigation Clinic, a clinic that was founded in the 1970s by another Rutgers law professor who became a Supreme Court Justice, Ruth Bader Ginsburg. She moved on to Columbia in 2006, where she's taught civil procedure, sexuality and gender law clinic, and other courses. From 2015 to 21, she served as Executive Vice President of the Office of University of Life at Columbia. During the Biden years, she served in key civil and human rights positions in the Departments of Defense, Education, and State. She's the author of a book, Strangers to the Law, Gay People on Trial, many law review articles on sexual orientation discrimination, sexual harassment, and other topics in such publications as the Yale Law Journal, the Columbia Law Review, and the Southern California Law Review, and also many op-eds, and is today attests a much in-demand speaker. So, Professor Goldberg.
So I'm so glad to be here with everybody today, and I have to say that I could probably just not say anything and just say, I agree with the prior speakers, and then leave the time for questions, which would be great. But, you know, being a law professor, instead what I'm going to do is say a lot of the same things in a slightly different way. But what I'm aiming to do really is to offer you a couple of different ways to think about some of what we've already been discussing. And I just want to say at the outset, though, I like the other speakers here, really congratulate all of you on the Law Review for pulling this off. It is, you know, both nothing to pull off a symposium, and to pull off one with this vision is really tremendous. And so thank you, and I hope it is as generative for you as it is for all of us who are speaking. The other thing I want to say is that I really appreciate, and Professor Titshaw said this at the outset, this sort of being able to do this in a place that really values community and mutual respect and an ability to exchange ideas. And that is really what we're about, right? That's kind of fundamental to the point. So I want to start with a comment on the meaning of legacy, because I think it is significant that you frame the symposium around legacy. And so, of course, I looked it up. And there's a variety of meanings of legacy, but the one that I assume that you are focused on is this idea that a legacy is something that is transmitted by or received from an ancestor or from the past, right? Transmitted by or received from an ancestor or from the past. And so in law, like a lot of things in life, like maybe the legacy furniture that you got from somebody in your, distant past of your family, right? Transmission doesn't happen in a vacuum. And I think we can just use for our vision, our metaphor, even just like imagine a car going down the road or a boat, right? It gets buffeted, or the car, right? It gets, you get a little messed up by the weather, maybe gets dinged in a parking lot, maybe gets scraped by somebody walking by, but all the things, right? It just, things change along the way. And also with cars, right? New passengers, new drivers kind of shape what the car feels like. And I don't want to overdo this particular analogy, but I think case law is a bit like that, right? I mean, the whole point of the common law is that we build on the past. I mean, that is what constitutional law is, right? Look to the past, and the past informs where we are, and it informs the future. And by the car analogy, right, we think about it's sort of the lane of case law, but it is also who's driving, right, which changes. And it is also the weather, which is, you might think of as society, that changes the way in which we understand what the development of constitutional law. And in constitutional law, every kind of case has a legacy, right? Cases don't just, come from on high. Decisions don't come from on high. They come from the past, and they also generate a legacy. And I'll say, I do teach civil procedure, and I think since all of you have at least been first-year law students, I can say that, you think about Pennoyer versus Neff, right, which I taught recently, and then you move on to international shoe, and the idea of minimum context, and it doesn't come from nowhere, right? It is a reaction, but not only to Pennoyer, also to, which was territoriality theory, a territorial theory of jurisdiction, if you can't remember that, which is fine. But also it is, it's changed because the justices change, the interaction of the case with society has changed, what's happening in the economy has changed. And so I want to think about the legacy of Obergefell in a kind of similar way, and focus on two ways that the legacy sort of exists, right? And one is to think about the rulings that come after, right? How do those either ding up or strengthen or buff up the vehicle that is Obergefell? And then second, what about the external conditions? What about the weather? What about, what's happening around us? And another, just one more idea that jumped out to me as I was thinking about legacy and Supreme Court cases is this idea of baggage, right? Like, we go through life, relationships or whatever. We all have, it's maybe not a complimentary way of describing it, but we bring baggage, or we could just say we bring our history with us. And I think the same is true for cases. So just to start, and I want to go back actually to the sort of the idea of immediate legacy, and something that John Davidson just said, which is right after Obergefell, Arkansas, a case came up from Arkansas that, in which the court refused to, or the state refused to put both names of the parents of a same-sex couple, a married same-sex couple, on the birth certificate of the child. And so the question for the court was, in broad strokes, did Arkansas have to do that in light of Obergefell? Obergefell recognized marriage for same-sex couples, but what did that really mean? And so when you think about legacy, it could have gone in a number of different ways. The court could have said, yes, you get to marry, but you don't get the attendant rights. And instead the court said, and again, I'm restating exactly what John said, but that the constellation of rights that come with marriage that were recognized in Obergefell are also part of the package. And so therefore, Arkansas, you must treat that married same-sex couple the same in all respects. So let's fast forward now to what is the contemporary legacy. How do we think about these questions now? So I want to divide the world of con law here into two areas. One are the cases that are adjacent to Obergefell in the sense that they're not about the right to marry for same-sex couples, but they are adjacent, they're about the same sort of foundation in the law, right? How does substantive due process protect rights sort of that are
deeply rooted in our traditions in one way or another. What does the Constitution actually protect when it comes to people's individual sort of ways in which we proceed to live our lives? And what is our interaction with the law? So obviously, and again, this is, I'm just giving a different version of John's talk here. But, Jobs versus Jackson Women's Health was decided in 2022, and the question in the case on its face had nothing to do with marriage for same-sex couples, right? It had to do with the Constitution's protection of abortion rights, of a person's right to terminate a pregnancy. And as you know, the court said no, right? The majority said no, the Constitution does not provide this protection. It did for a lot of years, and now it doesn't. But the question, as we think about this, of course, in Obergefell, and just to reiterate, the core question is, well, what is the role of the Constitution in protecting people's autonomy, in requiring some sense of equal treatment before the state, but also in enabling people to live their lives without undue interference, without the state sort of shaping your future, right? You're pregnant, in consultation with a healthcare provider, can a woman make a decision, I want to terminate this pregnancy? Or is the state going to come in and say no? Right? Can a same-sex couple living their lives go to the state and say, we want to get married? Or is the state going to say no, and the court will say that's fine? And so, as you heard, even though the court didn't have to address Obergefell at all, Justice Alito for the majority and Justice Kavanaugh, in concurring with the end of constitutional protection for same-sex couples' right to marry, had to talk about Obergefell, right? They felt that they needed, for some reason, to say this doesn't reach Obergefell. And in that sense, I think there was a little bit of a reaction to what you're saying, which is they wanted to say, no, that's not what we meant, right? We're just talking about abortion here. We're not talking about marriage. We're not talking about contraception. But there was no need to say that. Why did they say it? We can theorize about that. I don't think I have time to talk about all of my theories about why they said that. But I think it's a question for all of us. Like, why bother to talk about marriage rights? And I would suggest that one of the reasons relates to the legacy of Obergefell, which is it's a big deal, right, that the United States Constitution protects the right of same-sex couples to marry. That wasn't understood before. It had not been traditional. We haven't historically, over time, had same-sex couples have not enjoyed the right to marry. We've had it for 10 years under the U.S. Constitution. The right to abortion for 50, right? So what does it mean? Why is the court saying we're not going to go there now? Dobbs does not threaten or cast doubt on these protections. I think it's, again, part of adjacent shaping of the legacy. The Dobbs, the Obergefell car is kind of making its way down the road. Dobbs comes nearby. Is it going to knock it off? Is it going to scratch it? And the court seems to say, no, nothing at all like that. So another case, State Department versus Munoz, right? And the question in this case, there is a U.S. citizen, Sandra Munoz, whose husband, who's a citizen of El Salvador, was denied an immigrant visa without any clear reason. And so she goes to the court and says, I'm married to this person, right? The Constitution protects my right to be married to this person. Deeply rooted, connected in that constellation of rights is that I should be able to live with my husband. And the court says, no, marriage is a fundamental right, but you don't have a right to bring your foreign spouse into the United States. Doesn't say a word. Court doesn't say a word about, majority doesn't say a word about Obergefell. Justice Sotomayor for the dissent, which also included Justices Kagan and Jackson, says denying the husband a visa does burden the constitutional right to marry, that is to marry by preventing a couple from living together. And that is part of that same constellation of rights that the court recognized in Obergefell. So again, interesting, right? We've got this other case coming along. What does that mean? I don't think we know fully what that means for Obergefell, but the car keeps rolling along the road. Now I want to get to we're at the intersection, right, of Obergefell Street and the First Amendment. And so what happens there, this is, I would call these the cases that are adjacent but still about the marriages of same-sex couples. And I'll just mention briefly a few, right? So you may know that 303 Creative versus Elena's case, 2023. There the issue was a website producer from Colorado who wanted to make marriage websites specialized for married, announcing a marriage kind of websites. But she did not want to make those websites for same-sex couples who were getting married. And the question was, did she have a right not to do that, right? Could she hold out her marriage website services to the marketplace, but then say, but I'm not providing these services to you, same-sex couples, just to you, different-sex couples. And the court said, yes, that's fine. She doesn't have to do that. This was followed by a ruling just this past term in Mahmoud versus Taylor, where the question was, does a school have to permit parents to opt their kids out of story time if story time included books about LGBT people or LGBTQ people? And the court in that case said yes. And you might say, well, what does that have to do with the Obergefell car? And what I want to suggest to you there is one of those books, for example, was very directly about a story about same-sex couples marrying, right? But a storybook, not an adult treatise on marriage and not a marriage counseling book, like a story. And so what happens there? The court says, yep, schools must allow parents to opt out of this, opt their kids out of hearing these stories. So the court is not saying same-sex couples don't have a right to marry. And at the same time, I think we would be making a mistake if we thought that the 303 Creative, the website case, and the storybook case, Mahmoud versus Taylor, have nothing to do with marriage equality, because they very much shape the world in which, the road in which that Obergefell car is moving, right? That sometimes, the court will say, yep, people have a right not to serve you, and they have a right to keep their kids, at least in public schools, not exposed to your kinds of marriages. Not to anybody's marriages, just to your kind. And so I think it would be a mistake in the bigger picture not to see those as relevant. There's a case in front of the court right now, it was just argued, called Childs versus Salazar, and there the question is, can a state prohibit therapists, licensed therapists, from trying to change people's sexual orientation or gender identity? And you might say, well, what is that? And the argument that the therapist has made in challenging Colorado's law there is that the law is that it interferes with her First Amendment rights to interact expressively with her clients. And the predictions from reporters afterwards was the argument did not go well for Colorado, and that it is likely that the court will strike down this restriction. And you might say again, well, what is conversion therapy, this effort to change someone's sexual orientation or gender identity, a licensed therapist effort to do that, and the state's ability to regulate licensed healthcare providers, including therapists, and prohibit them from engaging in a kind of therapy that is widely viewed by professionals in the field as harmful, not just neutral, but harmful. What does that have to do with marriage rights for same-sex couples in Obergefell? So that is also an environment in which you may have a right to marry, but the state has no ability to say that this kind of therapy, so-called therapy, that is widely demonstrated to be harmful, that would tell people, enable a therapist to tell people something that is, again, viewed as harmful, sort of harmful healthcare provision, that, the kind of relationship you're looking for, you shouldn't look for that. You should change yourself rather than look for that relationship. It's not saying you can't, it's not interfering directly with the right to marry, but it is adjacent, and it is maybe, in a different lane if we think about the Obergefell car going down a highway. So I won't spend time, because I think my time is limited right now on the sort of external landscape, right, the weather. And I think John really spoke about, well, what are the societal conditions that also affect the legacy of Obergefell? But what I'll offer, just to, again, sort of distill a point or two from John is that it's not, when we think about the legacy of a case, we think about what are the cases that come after and how do they shape that case, our understanding of it. Do they ding it up? Do they strengthen it? Like Pavan, do they ding it up like some of the other cases I've just discussed, I believe do? But also, what is the environment in which that case is proceeding? And so there, when we think about the organized efforts that are gaining strength in some quarters, I don't want to overstate them because I think for all the reasons discussed, they shouldn't be overstated, to really say, what does it mean for the Southern Baptist Convention to enact a resolution specifically naming Obergefell? Say, we are going to work to overturn this court ruling. Right? What does it mean for elected officials in states to try to pass laws to say, we are going to restrict marriage rights for same-sex couples even after the U.S. Supreme Court has said the Constitution protects these rights? It means that a case, as it moves through the world and as it moves through our society, doesn't just stay as a discrete unit, right? It keeps being buffeted and changed. And so the question then, as we look to, well, what is the future? I know you can't imagine organizing another symposium right now, for those of you who organized this one, but imagine still, if you were to organize this in 10 years, what would be the different conversation we're having? And I hope and I do agree that for all the reasons that have been said, marriage equality is unlikely to be overturned, that Obergefell is unlikely to be overturned. But that's not the end of the question, right? Or it's not the end of the discussion. The rest of the discussion is how is the Obergefell car kind of buffeted along its road? What will it look like? Will it support more expansive rights and recognition for other people and the protection of not only same-sex couples, but the right, as we heard before, for people or maybe people in other kinds of relationships with non-adamant and non-people? Or maybe there are people, but they're not that. Sorry, I didn't mean to offend. Maybe they're full people, but not, you learn in law school about the differences in degree and kind. I won't make a judgment about what kind of difference that is, but I do think it is important to think about what will this look like? And then that's not just like sort of a passive observer question, because we all have a role in shaping the legacy. And so the question is, as lawyers and as people in society, what will you do? What will your part be in shaping the legacy of Obergefell?
So we have time for questions.
Now, you all mentioned that you really don't foresee Obergefell's decision being overturned, but in the case that it is, do you foresee a path for them to overturn that federal statute, which requires other states who don't recognize same-sex couples to have to recognize those states that do allow?
Only if they got rid of the filibuster, which may leave us any day now. But as long as the filibuster is in place, I think it would be tough to get 60 votes in the Senate for that. This won't poll well. One of the reasons I'm known as Professor Doom and Gloom. That's my nickname in social media. So one of the reasons I'm not Professor Doom and Gloom on this is it will hurt Republicans to undo same-sex marriage. It just will. And I think the judges know that.
I mean, I'd say so there's a political issue about will Congress overturn that statute. There is a question about whether the federal government has the power to tell states how they have to deal with their own marriage laws. And so, obviously in Loving and in Obergefell, they said you have to allow couples to marry. But it's a slightly different question about how they treat marriages from other states. Historically, marriages ended in one state do get respected in other states because, again, it creates all sorts of practical problems if they're not. And historically, that was in part because again, it was kind of this patriarchal notion, but that if you didn't, then the woman would no longer be a virgin. And so that would be a big problem if they weren't married. So we had to say that those marriages had to stay recognized, and that's going to be a different question with respect to same-sex couples. But there is this issue, and so then the full faith and credit clause comes into question of like, well, don't one state have to give full faith and credit to the judgments, acts, and records of other states? And then the question is, well, is marriage a record? Well, there's a marriage license. Is it a judgment? Well, sometimes there are judgments about marriage. And is it an act? Well, the question is, what did that actually mean when the Constitution was enacted? So, I don't think we'll know for sure, but I agree with Professor Siegel. I don't think Congress is going to do that. And again, I don't think the court has a real appetite for that because of the practical problems that would exist.
I'm not a conflicts of law person. Very few people are. But the full faith and credit clause has a big loophole in it, which is for something that contravenes the public policy of the state. I don't have faith in that issue. I think we don't want to get there. If we get to that point in the game, I think we're going to lose.
I'll just add something by broadening the frame. So I was filing a number of briefs in the marriage equality litigation along the way, and the brief I wound up sort of a theme of a brief that I filed in a number of cases was to look at the range of marriages that states recognize. And states are quite varied, right? In the minimum age of marriage, in consanguinity, can you marry your first cousin? States vary in what they allow there. And consistently over time, right, the federal government has never interfered with the state's ability to decide who gets to marry in their state. It is like sort of classically state-driven family law and relationship status. And so the idea that the federal government would come out and sort of swoop in and say this kind of marriage can't be allowed when we allow diversity of marriages across states in all other ways is also, I think, an older school or a broader argument against the idea that marriage, that the federal government could act, to prohibit marriage equality by states that choose to grant it if Obergefell was reversed, which for all the reasons have been said, I don't think it will be. I certainly hope it won't be.
Yeah, I have a question. I mean, we think about Obergefell, if I can say it, as about sexuality and marriage and relationships, but it's also about gender. And I wondered if you would speak to the social conditions that we're seeing, especially in the last 10 months, towards transgender persons in the military, and this whole question of professors being fired because they talk about the fact that there might be more than two genders, that kind of question.
I actually don't know if Obergefell is about gender. I mean, it is in some respect, but Bostock's about gender. I don't know how much Obergefell is. And professors being fired, which is a serious issue for all of us, especially down here. An Emory professor was fired for a social media post about Charlie Kirk. I don't think that's just First Amendment stuff in public schools anyway.
I guess I was thinking of it in terms of those social conditions that you were outlining, Professor Goldberg, that affect what our prospects do on this one.
I mean, yes, right. I mean, I think, it would diminish the point too much to say, to refer to it as the weather, but I think the weather actually is very significant because it's around and it's all the time and it changes. And I think it is impossible actually right now to think about any aspect of the regulation of sexuality or gender law. By regulation, I mean government action with respect to sexuality or gender. And I would extend that further to sort of in relation to identity, with the things that are crucial to people's identity, whether it's race or religion or a number of things, but just sticking to gender, that we would be making the mistake to see that even if the court wasn't originally offering a deep analysis of gender in Obergefell, which I agree, I don't think it was, even though that was an issue that was present, that certainly Obergefell is understood today in an environment in which there are fierce battles over gender and sex and what is it, what is the role of law in defining who people are, and based on that identity, whether people can access healthcare, can sort of, go to have books about them read at story hour, serve in the military. I mean, any sort of I do think there's complete connective tissue. I think for lawyers, I think there's a question of how much do you engage that connective tissue when you're arguing a case. And I'll just say one other thing. I wrote an article a while back that was called Risky Arguments in Constitutional Law. And the part of the exploration of the article was, why didn't courts, when analyzing the denial of marriage to same-sex couples, why didn't they just sort of rule on sex discrimination? It was the basis for the Hawaii Supreme Court's original ruling that in history sort of led to the Defense of Marriage Act. And part of what I wrote at that time, and I still believe, is that it opens a very large question for a court. We are a society that has organized itself, among other things, around gender, right? Are you, it's traditionally been restricted access to marriage. Anyway, we don't have time for all of that. That's a whole course. But the point is, do some arguments feel more risky to courts than others? And do some arguments feel like they require courts to think more sociologically than others? I don't think judges feel particularly adept at thinking sociologically or making determinations, or even if they do, I don't think they cast it in those terms. And so I think it's both present and then limited in the way that courts have discussed marriage so far, at least.
I want to disagree a little with the two panelists, because I think that Obergefell is very significantly about gender. They maybe didn't talk about it so much in the opinion, but part of what made Obergefell possible was the incredible evolution of how women have been treated in the United States, and marriage was historically inherently an unequal relationship where husbands were treated very different from wives. And over time, as a result of numerous Supreme Court decisions, the court started to say, no, that was sex discrimination, to say that men would have to pay alimony, but men could never get alimony. Or to say, there were all these restrictions. Women had to take their husband's name. We did not recognize interspousal rape as a crime. There were all these ways in which women were subject to men's control through marriage. They couldn't sign contracts if they were married. There were all these restrictions that started to disappear that meant that you didn't have to have a husband and a wife. And that we could see that marriage was really just a union of two people. And so I think that was essential to getting to where they got in Obergefell.
Can I respond to that real
Sure.
quick? It's just,
Now we're off.
and I just want to keep this real for 1 second. The following events were required for both Windsor and Obergefell to happen. First, Judge Bork didn't get the job.
Yeah.
Second, Judge Ginsburg didn't get the job. Both those people would have voted different Judge Ginsburg. He smoked marijuana with his students back in the day. So Kennedy was the third choice of Ronald Reagan. That had to happen. Otherwise, today, we wouldn't have this right. But more importantly than that, and the reason I think Obergefell as written, and there were no concurring opinions, is not about gender, is because we know exactly where Justice Kennedy's views came from, and we're very lucky about it. This was luck. When Justice Kennedy grew up in Sacramento, his father was a lawyer, a very well-connected lawyer, who had a friend who Justice Kennedy considered to be an uncle, not blood, but Uncle Bob, whatever his name was. He ended up being the dean of a law school. He was a closeted gay man, and Justice Kennedy saw the indignity, which is why he uses the word dignity in Obergefell in the very last paragraph. He saw the indignity of this man throughout his entire career, and I think it really bruised Justice Kennedy. We're very lucky that happened. If Justice Kennedy doesn't have that experience, that exposure to that person, Obergefell is 5-4 the other way, or if Bork's on the court. So we have to be a little modest in how much Obergefell, and as written, I think it is about the dignity of gays and lesbians, not about gender per se.
And I'll be a bridge here. No, I really just want to add three points. One, just to pick up on John's point, all of those sex discrimination cases, in some ways, make very clear to in law that marriage is, from the state's perspective, a transactional relationship. I mean, this gets to your point from earlier, right? It's not like the love part is the thing that the people hopefully bring to it, but from the state, it's what is your relationship to each other vis-a-vis your financial obligations, vis-a-vis the children that you have. It's what is the legal relationship. And when you sort of recognize how marriage actually functions in the state granted status and how issues related to marriage are adjudicated, it becomes very hard to say there's a need here to have people of the same sex or different sexes be in the sort of A option, the A and the B that are getting matched up in the marriage. So I think we couldn't have had Obergefell without the sex discrimination cases. I also think, I don't think Justice Kennedy was thinking about gender equality so much as the dignity and humanity of gay people who he knew, and I think it's often we see this in courts. There's just another interesting case from Justice Kennedy that had to do with an interpretation of the Family Medical Leave Act, the Hibbs case, and that was very much also him reacting, I think, in part to his experience of his daughter, who's a lawyer and a professional, and needed to take family medical leave. And so the question then that comes up for us, I think, as we think about the role of courts is, judges are human. They are, of course, having experiences that, of course, shape the way they react to the facts and the legal claims in front of them. And the interesting question, pulling on your observations, is should they own up to that not that obviously that can't be the only thing that matters when a judge is making a decision. There are lots of other things. I'm not suggesting that at all. But if part of a judge's life experience and exposure to the world affects how they adjudicate the claims in front of them, should there be something about that in the opinion, or should the opinion be entirely delinked? And I think what Justice Kennedy does, without referring back to his personal experiences, is to bring them forward in his ability to recognize people's humanity.
Just one quick sentence to add to that. In 1989, Erwin Chemerinsky was asked at a very young age to write the foreword to the Harvard Law Review, which is the biggest honor we can get. And Erwin said in 1989 that constitutional law is now, has always been, and will always be the balancing of values. There is nothing else. That's a direct quote. There is nothing else. So I actually disagree a little bit with you. I think not in property or tax, I don't know. In con law, it is values, 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 and everything else is commentary.
And I'll add one final thing on this point maybe, which is, I do think the weather right now is actually fairly hostile toward women's rights. When you start having the groups talking about trad wives, we need women to go back to traditional. Kind of like, should women be able to serve in the military? I mean, the issues that we thought were settled are coming up again because of the empowerment of the religious right, who again have certain views about the roles that men and women should have, and that the woman should follow several steps behind the man, and that it is the husband who should be the head of the family. Those sorts of views kind of have risen as this current administration listens a lot more to the people who view those. And even with respect to trans issues, I do believe that the kind of use of women as a reason to limit transgender people's rights is fundamentally coming from a sexist notion that women need this sort of protection. It's kind of using them. We're not seeing as many women's voices about what has to be done in sports and what has to be done with respect to restrooms. It's mostly men talking about their wives and daughters who need to be protected, which is very much kind of a sexist notion.
And now I have to connect it to one more point, and then I'm out. But which is that, and this really just draws from John's point, which is that when we read about challenges to democracy today, right? This is, connects it out from Obergefell to the weather on gender to democracy. There's a lot of writing entirely outside the United States that one of the ways in which autocratic leaders have claimed power is to restrict the rights of women, right, and LGBT people. And the idea behind that is it instantiates, through law and culture, this idea that some people have less or different value to the state than others, right? That not every person is of equal value, not every every voice is of equal value, every adult voter's vote is of equal value. And when you destabilize the assumption, which is an assumption in democracy, even though we know it's not always implemented, the legacy is always, the American story is trying to get there, but never having gotten there successfully. But when the push is actually not to try to get there, to further enable the voices of everybody to have a role in government, but actually to affirmatively restrict through restrictions on legal rights of various sorts, to cabining the rights of women, to cabining the rights of transgender people, to cabining the rights of gay people. And I'm not, obviously we can talk about voting rights, we can talk about entrenched race discrimination. There's a lot we can talk about, but in this connection between sex restrictions on women and restrictions on LGBT people, I think it is a mistake not to see the connections to risks to democracy in that sense, because it changes, these restrictions change the relationship of people to the state and the state to people.
Other questions? Yeah, we only need one question, we'll just keep talking.
I have a question. Well, first of all, thank you all for your presentations. It's been fantastic, and I've enjoyed this dialogue that you're sharing, and John, really enjoyed speaking with you last night in your keynote. Professor Goldberg, this kind of picks up on the idea that you raised about the weather patterns and the conditions surrounding these developments in the law at the court right now. And really, looking at the most recent case that you discussed, the conversion therapy case, and really how that arises in a fairly unique context, right? That we're not necessarily talking about the rights of that individual as much as kind of the rights of the state to regulate medical care, and then free speech rights. And during the oral argument, there were some hypotheticals about, is the outcome different if it's prescribing a medication versus a therapy type of scenario? And I guess kind of what I'm wondering is, what does the fact that the court took that particular case say about the weather patterns, and I guess kind of those discussions at oral argument and the hypotheticals that we're hearing at oral argument, what does that tell you about the forecast for the next 12, 18, 24 months?
Years.
Yeah. I mean, I have thoughts, but since I spoke last, maybe I'll have one of my colleagues can jump in, and then I will jump in. I think it's a great question. Thank you.
Yeah, I mean, I think it's interesting to contrast the concerns about kind of how much do we allow healthcare professionals to make decisions or not. And it's just so interesting that they said, well, if the state wants to prohibit the medical care that's provided to transgender minors, we're going to say the state can say medical professionals cannot give this sort of care. And yet it looks like they're going to say, And the states can not restrict therapists' care that's being provided. And it's like, wait, how are those consistent? Well, they're consistent in one way at least, which is we on the court don't really care what medical consensus is. That is, they decided, notwithstanding every major medical organization in the United States saying that puberty blockers and hormonal treatment to trans minors is safe and may be essential to protecting their well-being. We're going to ignore all that, and we'll say, oh, there's a big dispute, when there's not a big dispute in the United States. And the same thing is, like, there is unified views of the therapy organizations in the United States that conversion therapy is dangerous. So why doesn't the state get to regulate that? And I understand there are difficult First Amendment questions that are involved that are a little different when it's prescriptions than when it's talk. But I do think there's this run-through of, like, in the same way that Trump doesn't care at all about science, that's what we're seeing in the administration, is that the court doesn't seem to either.
And the other part of the weather that's out there, which is incredibly frustrating to federal courts professors, is, I wrote a blog post about this a few weeks ago, if the Alliance Defending Freedom brings a suit, and they brought both 303 Creative and the case you're talking about, all jurisdictional requirements are thrown out the window, and the court will hear cases where the plaintiffs have no injury, there's no standing, it's not right, and the case is moved. And that's a really frustrating thing, but it is a big part of the weather because it makes these cases easier to bring. Traditionally, public interest organizations, left and right, would have to wrestle with standing and rightness and all these jurisdictional requirements. I mean, standing is in the news every day. I've been quoted as saying standing is what standing does, which is true. This case in Colorado, she said she didn't use conversion therapy. She said she had no plans to use conversion therapy. She said she had no plans to have anyone, to make anybody change. So there was the 303 Creative case. She wasn't a website designer. She was going to be a website designer. She had never once done a website for a wedding. I mean, I don't think she ever did, by the way. The praying coach never went back to Seattle, et cetera, et cetera, et cetera. That is a big part of the weather, though, because it makes these cases easier to bring by public interest organizations like ADF, and the Supreme Court is currently in love with the ADF.
I'll add, I want to, John talked about the Scarametti case, right? The question in that case, came out of Tennessee, but, can a state restrict certain kinds of care, like puberty blockers and hormones, but only for particular types of diagnoses, right? Only for transgender, care that's needed by transgender kids, when the same care can be given to kids who, say, begin puberty early, right? And the court says, yes, the state can do that because the state gets to choose, sort of pick and choose among the medical science it wants to follow. Fine. But if the state does take that position, then the state can't take the position that, the provision of conversion, so-called conversion therapy, is dangerous because the state can't restrict in that way. Well, what's the difference? Is the difference that it's talk therapy and not, pills or medications from the pharmacy? And I actually think, certainly the First Amendment is implicated in one, not the other. But I suspect the Supreme Court would say that actually the state could restrict licensed therapists from taking steps that are known to exacerbate eating disorders, or taking steps that would encourage someone's suicidality. I think it's pretty clear the state could restrict those things, and those are also talk therapy. So that suggests then that the court is willing to limit the state's ability to impose restrictions when those restrictions relate to LGBT people. And that's a very different story. I would go back again to Mahmoud versus Taylor, right, where that's the storybook case. Can the state, does the state have to allow parents to opt out from story time if the parents object for faith-related reasons to the stories? There's a version of that's just the protection of parents and religion. And there's a version of that we can think about. This is an adjacent point, it's not the same point, that when we step back, what is the restriction on the state? What is happening there? The court is actually saying to the state, if half of the parents in your school want to opt out of certain lessons, you have to let them, on religious grounds, whatever they are, you have to let them do that. And what does that tell us? States, you can't actually run public schools the way you want to, and the way that you think is best in your professional judgment. And we might say in a certain way, like there's a way to tell that story, well, compromise is good. There's also a way to tell the story that actually the state is empowered and required to run empowered to run public schools. And now it is being disempowered, just as in Scrimetti or in the case of conversion therapy. The state is empowered to regulate healthcare providers. But in certain ways, we're going to not let it do that. And the question is, what's the shape of those ways that we say the state actually can't do the things that the state, or that are ordinary functions of the state?
And is it a blue state versus red state?
So I think we need to call it here. So thank you very much to the speakers and the questions, and people should have lunch.
Good afternoon, everyone. My name is Intisar Chowdhury. I am the Senior Managing Editor for Mercer Law Review, Volume 77. It is my honor to introduce our last panel of the day, Movement, Legacies, and Lessons. 40 years ago, civil rights legend Bayard Rustin described lessons from other civil rights movements that at the time similarly could inform gay rights activists in the 1980s. More recently, Evan Wolfson, an architect of the Freedom to Marry movement, has outlined several lessons of that movement that could be applied by activists in other fields, ranging from Palestinian peacemakers to transgender rights activists. Some activists may embrace these lessons, while others may passionately reject them. This panel seeks to explore how various civil rights movements have learned and borrowed from each other over time, possibly carving out lessons from current and future movements as well. This panel includes Shannon Minter, Vice President and Legal Director of the National Center for LGBTQ Rights, where he spent almost 30 years. We also have Adelina Nichols, who is a founder and executive director of the Georgia Latino Alliance for Human Rights, a community organizing and training nonprofit, where she has spent over 20 years. We also have Susan Goldberg, who you heard from in the previous panel. She is the Herbert and Doris Wexler Clinical Professor of Law at Columbia Law School. It is also my honor to introduce our moderator for this panel, Scott Titshaw. Scott Titshaw is the Associate Dean for Faculty Research and Development at Mercer University School of Law, where he teaches property, immigration law, and a seminar on sexuality and the law. Prior to joining the faculty at Mercer, Professor Titshaw was adjunct professor at the University of Georgia School of Law and practiced immigration and transactional law, 12 years with Arnold Golden Gregory, LP in Atlanta, Georgia. Please join me in giving a hand to our panelists and our moderator.
Okay, thank you very much. So this is the last panel of the day. I'm really excited. It's going to be a bit different than some of the other panels since we're thinking more, hopefully, sort of big picture and some about movement strategies and how movements influence each other. I'm really excited about our panelists here. You've already heard a bit about them, but I'll go ahead and introduce our first speaker, who is Shannon Minter. As you've heard, Shannon is the Vice President and Legal Director of the National Center for LGBTQ Rights, where he has been for, I think, almost 30 years. Yeah. He was NCLR's lead attorney in Christian Legal Society versus Martinez, which some of you may have read. That was a U.S. Supreme Court case which successfully upheld student group policies prohibiting discrimination based on sexual orientation and gender identity, and rejecting the argument that such policies violated a student group's right to freedom of speech, religion, and association. He was also lead counsel in California's NCLR's lead counsel in California's marriage equality case, and has been a leading advocate in the transgender rights field, winning cases on behalf of transgender parents, members of the military. Shannon also founded NCLR's Youth Project and has litigated cases on behalf of LGBT student organizations and transgender youth. In addition to practicing law, he is now also serving on the boards of Faith in America and the Transgender Law and Policy Institute. Shannon received his BA from the University of Texas and his JD from Cornell Law School, where I don't think he had Gary Simpson as a professor, but I think he was a professor at the time. So thank you very much, and join me in welcoming Shannon.
Thank you so much. Am I mic'd? I don't know.
The table is.
Okay, great.
Can everyone hear in the back?
Yeah, just checking because I know my voice does not carry very well. Anyway, it's so great to be here. Oh my gosh, this is like, I love this. I love this. I love this law school. I love being in Georgia. I love being in the South. I'm from Texas, and I've always felt the LGBTQ movement would benefit more from having more representation from the South and other parts of the country than maybe we've had. Anyway, yeah, I'm just going to talk, y'all, so bear with me here. I'm probably going to be a little bit more personal maybe than some of the others, but hope that's okay. I mean, I've had this experience of being very, oh my gosh, like completely immersed in the marriage equality movement for a really long time, and then also very much part of the transgender legal movement. I'm transgender myself. I just want to say this is so great that y'all are doing. I love this symposium. Y'all have done an amazing job. And I want to just call out that part of what's so great about it is it's not just about the issues and picking like something that's intellectually and politically important, but it really is about forging relationships. And I'm really feeling that here, y'all, because I just want to say it's really meaningful for me to be here with John and Suzanne. John helped me so much. I was like arguing the California marriage case back whenever that was, a long time ago now, and I was a very new attorney, and John, I will never forget, you were so kind, you were such a great mentor, and just really helped me. And then Suzanne and I first met when I was in law school and organized a symposium just like this one and invited Suzanne to come speak on LGBT asylum issues, and you ended up writing an article that was just like so seminal in that whole field. And you've been such a great colleague for so many years. I mean, that stuff really matters. I mean, that kind of relationship building, institution building, it's part of trying to make social and legal change. And this thing is important to call that out. The transgender legal movement has tried to emulate that and to build those kind of relationships over the years. But we have a strange, relationship to the sort of the more well-established gay movement that I think is kind of relevant to some of what we're supposed to be thinking about here. I mean, y'all probably know Sarah McBride, the first openly transgender member of Congress. She recently did an interview with Ezra Klein that was so good, and if you get a chance to listen to it, boy, I would encourage you to do that. She pointed out that for transgender issues, there hasn't been a strong public education foundation, which has left us very susceptible to misinformation, and that there's a lot we need to do to course correct. In some ways, we kind of have like sort of a foundation of sand because we were just piggybacking, kind of relying too much on an extension of general support for the gay community without really doing a lot of the work of teaching and learning that needs to happen. And what we've seen now is that sort of just assumption of support that's kind of overflowed from all the work that's been done around sexual orientation and gay issues, that's been ripped away from us now through just very, powerful disinformation campaigns, particularly about health care, that led to the outcome in Scrimeti, the recent U.S. Supreme Court case that upheld state laws banning medical care for transgender young people, and that is now fueling another case in front of the Supreme Court about sports and whether transgender kids can play sports. So, we're in trouble, really. We're now paying for that deficit. I think it was worth taking a moment to think about, like, marriage equality. It was such a perfect antidote to the way homophobia works. It's not just, I mean, I think part of the reason that was just so wildly successful is not just that marriage is important, and there was good discussion this morning about the pros and cons of like reinforcing the centrality of marriage as a legal and social institution, but it could not have been more a perfect antidote to probably the single most harmful stereotype about gay people, which is that they're incapable of forming genuine relationships. I mean, y'all, most people in here would be way too young to remember, but I mean, before marriage equality, most people in this country, when they thought about gay people, it was the antithesis of family. People thought it was purely sexual relationships based on short-term sexual fleeting interest, that you could not have a group of people more completely having nothing to do with family, raising kids, all that. And the marriage equality movement completely flipped that. Now when people think of marriage, they think about gay people. I mean, it was such a perfect way to undo the most terrible, vicious stereotypes about gay people. But we haven't found that perfect sort of lock and key issue for transgender people that gets at, that would promote that just sort of very powerful, structural, kind of widespread, increased understanding and support for transgender people. And I'll say a little bit more about some issues that kind of do that in a minute, but I just want to say that the leadership of people like Sarah McBride is just so important. I mean, we need, in the transgender movement, we need leadership that doesn't attack people who disagree with us. I mean, I think we're starting now to try to, make up for this and to have conversations that do allow for questions, missteps, for people to get a deeper understanding without feeling shamed or threatened. And we've really been hurt by the sort of sugar high of social media. It's just such a rush to kind of slam dunk someone on social media and call people out and all that. We have got to be so much more intentional about how we engage. And, remember that there are real people behind all these screens and find common points of entry. I've actually had a chance to work recently with some of the very best PR people in the world, like the same companies that are PR companies that work with like governments and corporations, and about how to counter misinformation and disinformation. And I was really surprised and real grateful to learn that the worst thing you can do when you counter disinformation is hitting it head on. If you take people on directly and be like, you're wrong, and let me educate you about it, actually makes things worse. And that you really have to meet people where they are and bring them along very gently and establish like some points of commonality and do that. It's a very delicate thing, and we have not been good about that. We're trying to do better, and I mean, one thing we're doing is much more using parents as messengers, like parents of transgender young people. They are by far our single most effective messengers for helping people understand what it's like, because they're very relatable. I mean, most people can understand and relate to other parents in a way that they just cannot immediately understand or relate to transgender people. We know from surveys and stuff like that there's still something upwards of, I think, like 76% of people don't know a transgender person, or if they do, they're not aware of it. I mean, that's a big deficit for us. Another example of something that is not as perfect as the way marriage equality just perfectly counteracted the central negative stereotypes about gay people, but it's starting to maybe get close, is a military issue, that the bans on military service by transgender people. That has allowed us to highlight transgender people who are serving in the military. And I think before that, probably most people weren't even aware that there were any transgender people in the military. But now I think people generally are aware, and it's allowed us to showcase people who are, instead of being seen as like mentally unstable, mentally ill, isolated from society, very marginalized. These are people who are like, anybody seeing these transgender service members who are challenging the ban is going to be impressed by them. I mean, they're patriotic, they're self-sacrificing, they're enormously skilled. Many of them have been deployed across, in combat zones multiple times. I mean, everything about them is contrary to the negative stereotypes that many people still have. So I think that has been a powerful public education tool for us. I want to say about the movement. I think there is some realization now that the transgender movement has become too ideological and too abstract, and I'm saying this as someone from inside. That after we made a lot of progress very quickly, but then we fell into the trap of allowing our movement to be dominated. I would even maybe use the word hijacked to a certain extent by a small group of advocates with very specific, very ideological goals, such as the goal, for example, of eliminating gender altogether, or who, rather than seeing transgender people as just a group of people with the same basic human needs as other people, instead see transgender people, or want to position them as the vanguard of some kind of revolutionary movement that's going to radically transform the way everyone understands sex and gender, and the way everyone lives. And I'll just say, I think this is very dangerous. Being transgender is in and of itself is not political. It does not convey any political message. It is not a revolutionary principle. It is part of the human condition. And I think the backlash that we're facing is, to a certain extent, a reaction against that, what I view as a very dangerous mindset, that some group of people, simply by definition of who they are, exist as some sort of contestation to the order of things. We're asking people to change their deepest beliefs and understanding about their own gender, change the way they think and live. I think one of the reasons we were able to achieve marriage equality is because we stressed that allowing same-sex couples to marry, that didn't affect anyone else. Our message was, hey, what do you care if two gay people marry? That's not going to affect you or your marriage. We stressed the commonality between gay people and others. But when it comes to transgender people, too many of our advocates have just forgotten all those basic principles of political change. We're not just asking people not just to live and let live, but to sort of affirmatively endorse all kinds of propositions, like the idea that having a binary gender identity, identifying as male or female, is inherently oppressive, or that gender is fluid for all people, or that we all should strive to live in a world in which no one identifies as male or female. I mean, look, it's fine for people to have these beliefs if you go for it, but those messages, though, are in suggesting that somehow all transgender people embody or emit those messages simply by virtue of being transgender. That is the very opposite of an effective strategy for winning public support or legal protection. I just say there's one influential activist, I won't name names, but has said, we're not just fighting for trans rights, we're fighting to end the gender binary. I'm like, no, no. We are in fact just fighting for transgender rights, which is simply our ability to live and work and love and have families on the same terms as others. Now, people can have these other fights, but I'm just saying, do not suggest that that all transgender people agree with that, or that the existence of transgender people somehow in and of itself supports your separate ideological agenda about these other matters. We should not be fighting to remake the world into our own image, and to the extent we're attempting to do that, we're making an already difficult struggle just infinitely more difficult, and actually at times I think really trampling on other people's rights. And I do think our larger movement is recognizing this and trying to get back on track and get ourselves back on the track of building community, sharing our stories, highlighting our humanity, and emphasizing to other people that we're really not here to lecture other people or to tell other people how to live or to demand that you agree with certain philosophical propositions about sex or gender, but just to allow transgender people to exist, to contribute and serve, and to do our part to make the world a better place. I don't really have time for this, but I'm just going to real quick jam this in at the end in my last 1 minute or something. And I just was so fascinated by the discussion of AI this morning. And I mean, y'all, we are seriously on the verge, as was pointed out, of something that could be approaching a moral panic about AI. And one very important element of the current conservative sort of right-wing attack on transgender people is to link transgender people with AI and to suggest that the same way that AI in transhumanism, the idea that we can transcend our physical bodies and live forever by uploading ourselves on the internet, that there's some intrinsic connection between that and transgender people, is a very prominent theme in this discourse. And I'll just give one example. There's a conservative policy analyst, Rachel Bovard, has argued that transgenderism, quote, serves as the beachhead for transhumanism, and that they both reject the body as given, treated as material to be manipulated. She says, if our culture can be convinced that male and female, the most basic biological categories, are malleable, no metaphysical limit is left to defend. You've got like Ryan Anderson, very big, very prominent conservative commentator, says that transgender activists promote, quote, a new form of Gnostic dualism where the real self is something other than the physical body. I know I got 1 minute left. I just going to point out that there is a very disturbing congruence between the elements, certain elements of the transgender movement that actually agree with this, but just they celebrate it. That to be transgender is to transcend gender, to transcend biological sex. It's an expression of human self-determination. That is sort of the leftist version of this rightist critique. And it creates, I think, a very dangerous political situation for actually existing transgender human beings. And I just kind of end with a plea to all of us to please, let's not fall into this trap of characterizing a group of people as completely just a representation of an ideological position, whether you love the position from the left or you hate it from the right. It is super dangerous. I mean, that is how people get severely scapegoated and put in some serious harm's way. So just a plea to help us get back to just genuinely humanizing transgender people and recognizing, at the end of the day, we're talking about human beings who just need the same kind of basic respect and basic legal protections as other folks. All right, I'm going to stop there. Thank you.
Thank you so much, Shannon. I want to now introduce Adelina Nichols, who lives here in Georgia. I think she's the only panelist who's a local, or relatively local, in the Atlanta area. Adelina is a founder and executive director of the Georgia Latino Alliance for Human Rights, a community organizing and training nonprofit where she has spent over 20 years. And this time I'm right about the 20 years?
25.
25 years, so almost 30 years as well. She has organized grassroots opposition to Georgia's immigrant detention policies and has led efforts for undocumented employment reform. She also provides education and resources to immigrant communities on individual due process rights. As a result of her work, she has been recognized by the ACLU, the Mexican American Legal Defense and Education Fund, the National Immigration Project, and Mundo Hispanico. She is a native of Mexico City, and Adelina received a sociology degree from the Autonomous National University of Mexico.
Yes, sir.
So please help me welcome her.
Thank you so much for the invitation. Well,
thank you for coming.
Yes, yes. I'm going to try to talk about a little bit the history of immigrant rights locally, but I will be kind of going regional, but as well nationwide. The story here in the state of Georgia began in 1999 when we began to organize ourselves on seeing the need of our community members to get organized as well. And we launched a campaign about driver's license for undocumented community. And we collect around the state more than 30,000 signatures that were delivered to the former Governor Roy Barnes. Of course, we didn't get the driver's license, but we were able to get to know who was out there, meaning in rural and middle and South Georgia. We were able to recognize the leadership that was willing at the time of the campaign to collect, to help us, willing to do something for their own community and for themselves. From there, we continue visiting and trying to organize, but since 2001, with the occasion of the 9/11, everything changed. The way that Latinx immigrant community were viewed, the perception completely changed. Sometimes we have community members that says, before, if my car broke on the highway, the local law enforcement used to help me, okay, what do you need, who I can call. And now it's like if your car is broken on the street or in the highway, run, because we don't know what is going to happen. So maybe this example could be kind of radical, but it's a perception as well that how our immigrant community here in the state start to change. And from there, pieces of legislation were presented here at the state capitol, denying access for public services for undocumented community. We didn't have a driver's license. And also, we felt how the local law enforcement was kind of harassing our community statewide, meaning that many people in jail, for driving without a driver's license. In 2006, this anti-immigrant climate continued climbing, and we have this national mobilization in 2006 against the Sensenbrenner bill, which is kind of the basis of the anti-immigrant bills since that time to this moment. And those mobilizations were able to put on the table the discussion of any kind of relief for immigrant community, or for later on you will know about the DACA and for the Dreamers, or at least an administrative relief to parents. In 2007, here in the state of Georgia, do this aggressive law enforcement. Counties like Cobb County and Gwinnett County signed under the 287G agreement. That means that local officers get deputized as ICE agents inside detention centers. First was the Cobb County, second was Gwinnett County. In 2008, a piece of legislation, another SB 350, was passed mentioning that if a person is undocumented and is detained under minor traffic violations, they will be paying a fine of $700 to $1,000 and plus 2 to 10 days in jail. That way, kind of putting people in jail, so the 287G agreement began to work and process and funnel people to be processed for deportation. In 2010, another piece of legislation really important that was passed in Arizona was the SB 1070, known as Show Me Your Papers. Here in Atlanta, in Georgia, we have the HB 87 that mobilized not hundreds of thousands, but the thousands of Latinos on the street to push back the implementation of this piece of legislation, Show Me Your Papers. And also in the region, Alabama had the HB 56, HB 56, and other states in the southeast as well copy the same piece of legislation implemented in their own states. And that's kind of the aggressive enforcement that our communities or immigrant communities has been through all these years. Sometimes when we go and try to explain to many people about the immigrant community and the existence of them here in the state of Georgia, we need to talk about and to understand that Latino community in particular is what I call the new immigrants in the southeast of Georgia. We don't have the history of places like Texas or California or New York or Illinois. Many of us, including myself, arrived in the United States in this part of the country in the 90s. I myself in the 96, and there are many stories about that many people was brought from Mexico in particular to help to finish build the buildings for the Olympics. many people was brought from California to help to finish and have the infrastructure ready for that. So, no, there are many elements that are playing here. It's not only that we have the free trade agreement, in particular in Mexico, that devastated all the agricultural sector. Mexico was unable to compete with the United States and the subsidizing, no, that provides to the agricultural sector here in the United States. Anyway, in 2013, there was the first attempt to pass the immigration reform, and the bill was passed on the Senate, but didn't pass on the House of Representatives because they didn't have enough votes to do so. So we didn't believe that something was going to be like for real, no, immigration reform. So a bunch of organizations under this initiative called No One More Deportation, we move along in a different direction besides the Congress. So people from Arizona, Los Angeles, Seattle, Texas, Georgia, North Carolina, Boston, Philly, many organizations, nonprofit, decide to go into Barack Obama, the president at the time, to request the expand of DACA, ¿verdad? And DAPA, meaning DAPA was for the parents of those students that got DACA, and we wanted to include a little bit more of the our youth into the DAPA proposal. And we initiate this struggle, fighting back with civil disobedience in detention centers, here closing the ICE facilities, in Seattle as well, closing the Tacoma Detention Center. Many actions took place, and finally, on November 20, 2014, the President Barack Obama enacted this executive order that opens the door for the expansion of DACA and DAPA for the parents of those students. But 2 months later, 26 states, Republican states, filed a lawsuit against the President Obama, of course, so that canceled the opportunity for communities and immigrants nationwide to have this capacity to have a relief, no, in terms of their immigration status. In between the years, and let me just get back, between the years of 2006 and 2013, no, we have numbers. For example, in Gwinnett County, more than 50,000 people was arrested under the 287G. And out of those, more than 35,000 people was processed for deportation. What does that mean? Means that many kids were without a mother or a father or both, because they were processed for deportation. So it's similar what is going to happen now, but worse. And then I remember in 2007, I think there was in Georgia 1 or 2 immigration lawyers. I don't know how many were, but not accessible to us. So we learned to file stay of removals. We learned to fight prosecutorial discretions. We learned, like in terms of their own experience, fighting and pushing back what we thought is unjust. But we thought that until this moment, many communities, many sectors of the industry, could be agricultural or construction, have benefit by that workforce of immigrant community. And we haven't seen them around, supporting and defending their own workers. And that's a concern that we all have. And in 2018, here in the state of Georgia, due to that demographic change, meaning that the first generation of Latino was like jumping, we decided to move into the civic engagement world as another community defense strategy, moving and canvassing and kind of debunking as well this myth that Latinos are not interested in elections and they don't want to vote, and this is the reason that they didn't show up, no? Because we don't care. Yes, we do care, but there's not investment on that. We decide to take all these years of our skills on grassroots community organizing to put it into the civic engagement and kick butt, no? To move around statewide. Therefore, in 2020, we were able to canvass more than 140,000 doors in the Gwinnett and Cobb, flipping the 287G and putting the new sheriff for the first time, African American sheriffs in these both counties in the last 20 years. At the same time, we continue. We are here using different ways of moving, but in terms of tactics and strategies, for many years we were kind of against the state. I can describe this as a way to build power. Was against the state and without the state. In 2018, due to the demographic change, we decided to move into within the state. And from 2018 to 2025, we have been using these build and power tactics in different levels and at different capacities. What we see today is unbelievable. What we once join and enjoy even having civil rights, all these vindications gained by the civil rights movement with our brothers and sisters, African Americans, looks like for immigrants it doesn't work, And we are facing these attacks with a deep family separation, violence, aggressions, kidnaps. You don't know where is your sister, your brother, because I don't know where it is, and disappear. You cannot find in any detention center, local police, and appears 2 weeks later in another side of the country. So due process, none. So this is the world that we are now, and this is the country that we are right now. And I do believe that this is just the immigrants are the excuse. I think that later on this can span to other sectors of our community that are already not feeling the heat of these policies that are impacting our families. We believe since the beginning and inception of this organization that our best policy was humanism. And humanism means putting a principle, the human being, the benefit of the people. To this day, I only can say, and I am going to finish, that the only people can only save the people. That's kind of the slogan that we are moving into these new times that are very difficult, not only for Latinos, for those communities of color at large, and now inflation, attacks, due process violations, constitutional violations, it is a mess. But we are here, we are resilient, we are going to fight back. Thank you.
Thank you very much, Adelina. I'm going to, I think, shorten Professor Goldberg's introduction.
You can skip it entirely.
And I'll mention a couple of things I think I don't recall. Professor Simpson mentioned earlier when, and maybe I missed it, but when Suzanne was at Lambda Legal, she was, and maybe he did say this, but she worked on both Romer v. Evans and Lawrence v. Texas, which were huge landmark cases that I know my students in my Sexuality in the Law seminar have read. And she is really one of my heroes from the, gosh, maybe 20 years that I have known her. So I'll leave it at that since you got most of her bio earlier. But please help us welcome Suzanne Goldberg.
Thank you so much, Scott, Professor Chicha, and you are one of my heroes as well. And really, it is an honor to be on this panel with both of you. And like Shannon said, we've come a long way since I was at I guess I was a young lawyer at Lambda Legal and you were a young law student. And of course, a pleasure to be able to be with John, who's been my colleague and friend for a long time, and speak and participate and be in conversation with all of you. And I've committed to myself, I'm talking for shorter. We're going to have a bigger conversation. There's lots to talk about. But I want to ask, as we think about the legacy of Obergefell for social movements, to sort of pick up, actually, Adelina, where you left off, which is, what does a social movement do when things are a mess? I mean, social movements are movements by definition because they're trying to move somewhere, change something, move a group of people in some kind of direction. Sometimes it's vis-a-vis the law. Sometimes it's entirely unrelated to the law, but it's sort of to move into the sort of making sure that a group of people is recognized in their full dignity and humanity, and sometimes it is some other effort to change society in some way, right? It's a social movement. And so I want to ask each of you just to think for a moment about a social movement that you are part of. And if you don't, if nothing comes to mind, you've certainly read about a social movement. I think if by the time you're sitting in this room, you surely have. Maybe there's one that you admire, that you've studied, that you've been intrigued by. And think to yourself, like, what makes it a movement, right? What makes it a social movement? What are the elements that go into that? Because we can't really think so much about what are the legacies even of Obergefell for social movements if we don't have some sense in our heads about what a movement is. And we may all have different senses. We don't have to have the same one. But what I do want to suggest is that movements obviously involve people, right? And, clearly. But they're also about ideas. And they're also manifested often in strategies. And all of those things that define a social movement change over time and in circumstances. And just to refer back to the earlier discussion, change as the external conditions change, as the weather changes, as the barriers to success change, the social movement adapts. And on all three dimensions, right? On the ideas, what do we want? Who's leading? Who's participating? Who do we want? Whoever the we is, who do we want to participate? Who sees themselves as part of this movement? And what are the strategies and how do those change? Because of course, let's say you start out with the goal of marriage equality, and they're like, okay, we're going to start small and work in the state courts and try to just do some work with the communities in all the ways that you've heard about. And then the Hawaii Supreme Court denies a motion to dismiss of the state of Hawaii and says essentially that the Hawaii same-sex couples who are seeking the right to marry, the freedom to marry, but the constitutional right to marry, that they can go to trial and actually maybe have a chance of getting that, winning the right to marry, and they actually start to go to trial. And so you're thinking like, okay, great, we're making some progress. But then people in Congress get very upset, and they decide to pass a federal law called the Defense of Marriage Act, that when you're starting out thinking about your marriage equality strategy, you're not necessarily thinking, and one of the barriers that we're going to face in the strategy is going to be a federal law that actually, across the country, tells states they don't have to recognize other states' marriages, and says the government that affects everybody in this country will not recognize those marriages. So you have to adapt, right, and think, okay, this is a new problem. How are we going to handle it? And what I want to suggest is that is the task of every social movement. And maybe the thing that is happening doesn't look like the Defense of Marriage Act, or it doesn't look like the President of the United States issuing a raft of executive orders declaring that transgender people do not exist and using the full powers of the federal government to not only render transgender people non-visible, but also affirmatively discriminate, including in some of the ways that Shannon described. Or, by the same token, exactly to Adelina's point, you're working along, having a lot of success, even if it's sort of ebbs and flows, and then something changes in the politics. And now suddenly, instead of sort of the progress that you were making on, with respect to the recognition of the rights and the humanity of immigrants, is sort of, it gear shifts in a totally different direction. If a social movement doesn't adapt, then it's missing the point, right? It renders itself irrelevant because then it's responding to things from the past and not things from the present. And so again, ideas, people, strategies are all going to be dynamic. And so when you think about a social movement, or I think about sort of the impact of Obergefell on the LGBT movement in particular, but on other movements as well, which I'll say something about in a moment, we can think about that. We can ask the question. We can think about any movement at a high level is the overarching goal remains basically the same. Right, the full dignity and humanity and legal protection for group X or for activity X, if it's the social movement to decriminalize marijuana. But apart from like that, the super goal, right, the superstructure of the thing you're doing, everything in that sort of, I don't want to go back to the car analogy. But you know where you want to get. But the paths you take and the vehicles you use and the people you bring along will change over time to adapt to the circumstances. And so I want to raise the question then, well, what about when a social movement goes to court, right? And so I actually want to go back in time to invite you to think about this question with me, a predecessor of Obergefell. So in the mid-1980s, it seemed like all of the Supreme Court's jurisprudence related to women's rights, related to reproductive rights, related to the right of individual autonomy to pursue your life, make decisions about birth control, make decisions about terminating a pregnancy, make decisions about how do you educate your children, there's tons of protection. And everything seems clear, right? There's a path cleared for the Supreme Court to recognize that, of course, the Constitution protects the right of individuals to have adults to have consensual sexual relations in private with another adult. That seems like duh, right? It just follows. But of course, Bowers versus Hardwick said no, it does not follow, and that the mere, the moral disapproval of a majority of the electorate that the court presumed was enough to justify upholding Georgia's sodomy law at the time. So what lessons does that have for us in connection with Obergefell, in connection with today? I want to, it's got a lot of lessons. It actually, when that decision happened, it was one of those sort of experiences of what our colleague Evan Wolfson calls losing forward, because it turned out that a lot of people were upset by that decision, and so that negative thing, that bad thing that happened, actually mobilized a lot of lawyers and a lot of other people to join and re-envision a social movement, because now there was something really specific to fight against. And when social movements have an adversary, right, there's pushback on the movement, movements can sometimes draw strength from that to organize. So that may be one lesson or observation. But I think another one is what I want to call the importance of multidimensional advocacy. And this is, I think, a legacy of Obergefell. The movement for marriage equality did not create the ideas of multidimensional advocacy, but I think it crystallized them in an important way that other movements have drawn on. And so what do I mean by that? Right? There's a lot that happened between Bowers versus Hardwick and Obergefell. I mean, there were things that happened at the Supreme Court, right? The court did strike down sodomy laws in Lawrence versus Texas. It did strike down a Colorado amendment that banned the state and local governments from protecting lesbians, gay men, and bisexuals against discrimination. There was the battle over gays in the military, a lot of stuff. But one of the things that happened within Obergefell is that the battle for marriage equality was very intentionally waged, if you want to, I hate to use the battle metaphor, but I'm in it now, but it was very intentionally waged on a lot of different levels and in a lot of different places in the ways that you've heard just talked about, right? in state legislatures, in conversations, in faith settings, in bars, in social clubs, in bar associations that were debating, should we file a brief or not in this or that case. And the point of the multidimensional advocacy, as I often say to my classes, is that when you have a goal, and let's say it's a legal goal, like marriage equality, so if a social movement has a legal goal, it is the obligation, I think, of the social movement, including the lawyers, to think about how do we create the landscape that will help the court be amenable to saying yes when the question comes to court whether marriage equality should be recognized, or the rights of immigrants, or the issues facing restrictions on transgender people right now, or reproductive rights, or a million issues. And so how do we ready that landscape? And one of the things that lawyers typically do, right, is we think a good argument, that's great for readying the landscape. And it turned out in Bowers versus Hardwick, of course, a good argument was not enough. And in fact, for many years after the lesbian and gay rights movement lost Bowers versus Hardwick, we would talk about that there's a gay exception to the Constitution. Right? It was just so clear the Constitution was heading in one direction, now there's a little hole cut out for gay people. And so if you don't want the hole cut out, legal arguments are not going to get you there all the way. And so the real lesson of all of this, I think, is that from Obergefell, is the connection between the head and the heart. And I'm really just saying in many ways what others have already talked about. But I think what Obergefell did in a very successful way was to do that intentionally, right? Was to recognize that you can't just make good arguments. And I don't even mean the kind of like the arguments that are sort of respectful, intellectual, good arguments, but you can't just make great arguments. That's not often what moves people, right? And so but you have to have good arguments to win in court and often to win, for certain people. But that's not why most of us shift our views. And so I think what we're seeing across many movements, from immigration to gun rights advocacy to decriminalization of marijuana to repro rights to trans rights and others, is to really think about how do you reach head and heart. There's actually a great quote from George Washington, who I probably wouldn't have talked about himself as the head of a social movement, but he was in some ways, right? The social movement of what is this country going to be? And he talked about, I don't have it off the top of my head, but he talked about how you have to reach people in their hearts, and then they'll come along. And so a question that I always ask my classes that I would just ask you, I ask myself all the time too, is when's the last time you changed your mind about something that is important to you, like not what restaurant you're going to, but something you really, like a belief you were committed to. And then the next question, I was probably too fast on jumping to the next question because it's hard to remember often for a lot of us. And then the next question is, what were the conditions that led you to change your mind? Right? Why did you change your mind? And to go back to something Shannon said, for most of us, it is rarely because we're told, we're wrong, or stupid, or offensive, or a bigot, or any of those things. Those don't generally open the heart. So what does? There's a lot of research on this that, we're not going to talk about today, but a lot of research just in the messaging world that talks about the importance of third-party validators, right, outsiders to the movement who can say, I changed my mind. And John talked about that last night with the example of Barack Obama talking about his views evolving on marriage equality. But there's also the idea, I think, fundamentally, when we think about what leads us to be able to even be open to changing our minds, even if we don't ultimately, that we are received with respect. And that whoever we're engaged with is genuinely interested to know, what do we think? Right? Why do we believe what we believe? And then that enables some pathways to reach the other person. I want to say, I don't think it's ever a guarantee, right? I think there are extremely compelling arguments to be a vegan, right? There are agricultural arguments, there are animal, the sentient beings arguments. I'm still not a vegan. And the lesson that I take from that, for myself, is there may be very good heart and mind arguments, It doesn't always mean you win. But what it does mean is that when we are able to interact at both of those levels, and not just be sort of lawyers and law students and all in our head about it, but when we're able to interact at both of those levels, we create the possibility, even if not for complete change, for an environment in which there is mutual respect and room for people to embrace each other's ideas, and a commitment and even a desire to create space in which all people can thrive, even among our differences. And so to me, one of the great legacies of Obergefell is it took a lot of those larger ideas and it crystallized them into a set of strategies, into a set of arguments, and into a way of interacting and approaching and respecting people across the spectrum that really did lead to meaningful social change. And so again, I'll just end with an invitation to all of you to think about what is your role and what can you do in all of this as we all, in different ways, strive to achieve greater social justice and greater justice for all.
Thank you, Suzanne, and thank you all three. That has really been provide us a lot of information and a lot of things to think about and to ask, I suspect. I'm going to ask one question before I open it up to the audience, just because some of the things that all three of you were talking about regarding the need to humanize people in a movement, the head and heart argument. One thing that occurred to me long ago when the Freedom to Marry movement was just revving up, and frankly, I thought it didn't stand a chance in heck. I know that before that, I still thought it was a brilliant movement, even though I thought it had no chance. And the reason was, before that, in the 1970s and 80s, the whole discussion about LGBT rights at the time, it was gay rights mostly, and it was mostly focused on men, and it was mostly focused on either HIV or on school teachers, and this idea that gay people couldn't reproduce, so we recruited or we molested, right? And the children were on one side of the equation, and it wasn't our side of the equation when the arguments were made. And I thought bringing the argument into the context of marriage really moved the children from one side of the argument to the other and made a really compelling argument. And what I wonder is that one, the effect of discrimination, subordination on children, is that something that you think can commonly be used in a lot of movements to compel people to, through their heart, to feel something where they otherwise might not? I can open that up generally, but I wanted to start with Adelina and the idea of dreamers. That's children who were brought here unlawfully, they weren't necessarily brought here unlawfully, but they're out of status now. They were brought here as children. They were children. And it seemed like some of the first sort of federal movement was in that area. Could you talk about that a little bit? Is that something that you think was particularly helpful because it was children?
Yes, the Trail of Dreams, was one of the events that took place in, I guess it was 2010. Four individuals decided to walk from Miami to Washington, D.C., carrying the flag of undocumented and proud. And just put it on perspective as well. No, you have the Sensenbrenner bill that was mobilized in 2006, a lot of immigrants nationwide, but also these small initiatives that were effective but didn't last. Mm-hmm. No, and basically in terms of who is in politics, who is in charge, how they see immigration, and but it was for us very important. I remember, and I don't know if I can say it, bad words here. For example, no, mi gente is our political hub, and they put out this chinga la migra, no, like if I translate.
It's an insult to the
To the
immigration
migra,
authorities,
yes.
yes.
To the migra, then at the beginning we were like, oh no, que como vamos, how I want to say eso, you know? But later on, oh my God, it's like, no, let's go, let's move, and let's do whatever we need to do. But I think it's important to recognize the force of the youth, no, the force and how important is their presence in terms of social movements, no? Not only for Latinos or for immigrants or for any other social issue, but at large. The responsibility of the youth at large is huge. And Turtle Dreams, no, was part of this initiative. Like, let's go.
Yeah, thank you. And I'll let the two of you, if you don't have to address that precise question, but how do you think you move heads and or hearts to move heads, I guess? How does that, what advice do you have for us?
Well, Scott, that's such a great point. I mean, all the way back to Brown versus Board of Education with focusing on the children and the damage to their hearts and minds that might never be undone, that famous line from the court. And yeah, I mean, gosh, I mean, Suzanne, John, I mean, getting the courts and the public to care about children with LGBT parents, with same-sex parents, was such a central strategy. And, you know, there was that line in of the marriage equality movement. There was that line in Bowers that the very idea that there was any connection between gay people on the one hand and marriage, family, and procreation on the other was facetious. The court said it was literally a joke. I mean, to just completely turn that around, it was seriously brilliant. It really was. In Obergefell, the most heartfelt passages in Obergefell are Justice Kennedy just extending his clearly very authentic, sincere sympathy for these children whose families are being stigmatized, and the children, you know, you don't get to choose your own parents. But you know what you just made me realize is that we are having a very difficult time doing that with transgender people, because people are highly alarmed by the very idea that there could be a transgender child. People have a lot of resistance to that. They don't believe it. The idea that children would, you know, it's not till they're teenagers, but that teenagers would require any sort of medical treatment to facilitate a gender transition. Boy, that is an uphill battle. And you're causing me to think that that is probably why, one of the reasons why we have more wanted to focus on parents and let the parents be the sort of visible face and talking about their love for their children, and that's so much more relatable. That's a really interesting point.
And maybe building and connecting a little bit. I mean, I do think that's right, like that children can sometimes be a path for helping people see the humanity of others, and it doesn't always work, right? I mean, obviously, we have a history of slavery in this country that you know, is Exhibit A. I think exhibit, you know, another very important exhibit is, you know, the treatment that did not send most Americans up in arms when children were being taken when they crossed the border and held in cages, right? Or separated from their you know, and not sort of connected to the people who they were connected to, you know, outside of immigration detention. And so I think that, to me, also, you know, speaks to having our heads about us. Like, it's not always like the heart argument that I might think this is going to be a great argument. You know, not everyone shares that, right? And the heart argument that you might think is a great argument, I might not share that, right? Just to go back to my vegan example, right? There's intellectual and sort of emotional arguments to be made. But I don't think that's the end of the conversation. You know, to me, what that provokes is, okay, that's good information. And I can use that information to try to adapt my strategy. There's a quote that from Nelson Mandela that I love. I mean, many quotes from him, but the one that's pertinent to this discussion, which is, I think it's him. I hope I haven't messed that up. which is, you know, I win or I learn something, right? There's the idea, like, we're not, just because you don't win on round 1 or round 10, I mean, look, the LGBT rights movement has, you know, worked for decades just toward, or the lesbian and gay movement toward decriminalization. You know, toward the idea that if there's a sodomy law in place in Georgia, then can a gay person be a police officer because they're a walking criminal, right? If they, you know, or they are perceived to be somebody whose life exists in violation of a law. How can they get hired by the state? And there are cases in Georgia about that, about a law student actually whose job offer with the Attorney General was withdrawn after the Attorney General found out, State Attorney General found out that she had not a marriage, there wasn't marriage then, but a commitment ceremony with her partner, her female partner, and she lost her job because the AG said she's in violation of Georgia law, Georgia sodomy law, we can't have her be working, prosecuting people for the state. There's a lot of interesting stories about that case, but my point here really is, you know, in a social movement to be able to see the points of loss and the indignities and the just like this sort of utter disregard for whatever, you know, people's human rights as not just the end of the conversation, but as information that has to be taken account of as you adapt your multidimensional strategy going forward.
Thank you. And for all the law students out there, if you're looking for that case, it's Shahar v. Bowers. So, or maybe it's Bowers v. Shahar. I don't recall where it ended up. But if anyone has a question, I would love to open it up to the audience. Professor Carlson?
This might be an impossible question to answer, but when I think about the strategy of changing hearts and minds, I think immediately about some of the extreme vitriol on the other side and some of what seems to me to be a closed-mindedness where that approach would just not be successful no matter what. And I think that that's a small percentage of people, and so I don't know if the approach to those people would be different or the same or what it would be. But do you think that kind of open animosity on an individual and a societal level and on a governmental level now is different than what these movements have faced in the past? Or do you think it's the same and maybe just taking a new form? I guess I'm asking on behalf of those of us who weren't necessarily around or having memories of what exactly was happening like around the time of Bowers versus Harlan.
I have lots of thoughts, but
no,
I just...
You should go.
Go.
You go.
You go.
You go.
Go ahead.
But I can tell you that I am just happen to be the executive director, you know, but I think about myself as a grassroots community organizer. And I have been traveling this state for 25 years. And the way that that we believe is that mind change, is that create this critical conscience, is talk to you face to face. That's the reason that to create change takes time, no? To create this political conscience or critical conscience at least, no? To get to know and to build trust. I think it's possible. No, there is an author in Mexico that says that we believe in utopias. But you think that the utopia is on the corner, but when you go around to the corner, that is not there. So, maybe it's in the other corner, and you are running, and that's part of this struggle for freedom, for dignity, no, that can embrace more people in your way to the utopia.
Mm-hmm.
Utopia. I don't know if it makes sense what I am saying, but I think this. I think it's important how in the things that you believe, and if you believe it, everybody will understand. No, and part of the struggle is not the same. No, we have learned from the civil rights movement. No, and from there some experience and some lessons we have carried with us as well. No, it's not the same, but the way that now the immigrants and trans rights and LGBTQ rights and even African American communities, situations that are happening with police brutality, mass incarceration, I think is different. It's different the way that they are acting now. With this, they have permission. They have permission. 74% of people being detained and processed for deportation do not have any kind of criminal or any kind of background. So that is telling you that papers or not papers, it doesn't matter. The color of your skin or the way you speak with accent or maybe you are poor, or you are black, or you don't have enough education. That's things that are being criminalized right now and being criminalized for a long time. It's not the same as the civil rights struggles, but at the same time, that doesn't mean that it's correct and we should stand still and wait for whatever is coming.
Yes, that really resonates what you just said. I do think it's different now. I mean, our country, it's kind of hard to say that because there's been such horrific history in this country of racial violence and violence against immigrants and homophobia and all that. So I'm aware of that, but it feels like what's happening now is different than the sort of reflexive types of animosity and hatred and violence that we've seen before. This is like people very deliberately and intentionally setting out to like re-demonize certain parts of our population, like immigrants, transgender people. It's kind of scary. I don't know, Suzanne, what do you think?
Yeah. I think there's an argument for, discontinuity, right? That what's happening now is different. The level of money behind what's happening now is different. The level of global coordination among autocratic leaders is different. If you're curious about that, you can read Ann Applebaum, Autocracy, Inc., and anything that she's written that kind of lays that out. And then there's an argument that it's continuous, right? Our government turned dogs on kids, right? Fighting for civil rights, right? That that's one of many enormously vivid images. So to me, then there's kind of two questions, and to choose somebody else who is not Ann Applebaum, Mel Robbins. Have you heard of her? So she's like a super popular podcaster. I actually didn't know much about her until recently, but she's got this extremely popular, most best-selling book in Let Them, and I don't know the whole title. But her point, I'm going to riff on her point because I'm not sure this is her point. But what I took to be her point was, like, they're doing what they're doing, whoever the they is, and that they could be, your spouse or your boyfriend or girlfriend, or that they could be the government. They're doing what they're doing, and the question for you is how to react. Like, that's the thing you can control. You can't control what somebody else does. And so if you have all the money that you can feed into, sort of match money for money, match military for military, then those are strategies available. Anger is always a strategy back. To me, it's just not my temperament, so it's not where I go. But what I would say to those of you who are inclined that way is just use it strategically, right? So take account of the kinds of points that Shannon made earlier about what the messaging people say, which I think is certainly true, right? It doesn't usually change minds. But also you might say to me, well, it's naive to think it's about changing anybody's mind anymore. And I guess I would say, it could be, but like, what's the alternative? And so I was on my phone because I think I think you think about what's available to you to do. And what I was on my phone for was looking up just to make sure I got the quote right. And I was reminded, so in 1967, at the Southern Christian Leadership Conference in Atlanta, right, the conference was Martin Luther King gave a speech that was called "Where Do We Go From Here?" Obviously, it was a very difficult time in the civil rights movement. the forces of the government were largely arrayed against the protection of and the humane treatment of black people, at least at the federal level. And this quote, which I'm sure you all know, is I have decided to stick with love. Hate is too great a burden to bear. And it's not, obviously it's not to say be naive. And yet it is also to say, as you think about wherever you come in on the multidimensional advocacy strategy point, what is the world you want, and any of us wants, and how do we create it, and how do we think ultimately, whatever our intuitions are, that yours don't have to be mine, but how do we think about reaching the people we can reach, and then the people we can't reach, the Autocracy Inc. version, what do we do to marshal resources to address that? And that may be everything from getting together with very large groups of people to other kinds of civic engagement strategies that we're seeing around the world.
Thank you. And actually, Suzanne's point there was echoing something that Bayard Rustin wrote, which I had, which was also basic, to really paraphrase, he basically said that there are some people who just hate you and you can't change them. And you just have to forget about them or deal with them. But then you have to, the people who aren't there, and I guess Evan Wolfson's idea would be the people who, not everyone who is not yet with you is your foe, so the reachable but not yet reached, you can reach out to them and find strategies to.
And if I could just add one thing to that, right? Some of you probably studied political science undergraduate, and there's sort of intensive, I forget, what is it? Now I'm going to get the words wrong, but I think there's a political scientist or two in the front row, but like the intensity preference, right? There are groups that are very intense in their feelings and expressions, usually on either side of an issue. But many more people are in the movable middle. The challenge with social media right now is it makes it seem like everybody is on one pole or the other, but surveys show consistently that that's actually not most people's day-to-day, either the way they live or the way they want to live. And so that also is part of why I think be strategic and also, think about the kind of world you want to live in, and also that fundamentally, like, some people are really truly going to be very, very different, but most people are kind of going to want to meet somewhere in the middle.
And I think we have time for at least one more question. Yeah.
So there was a lot of talk about strategy, and so my question to you all would be, how do you balance, on one hand, you have real people with real interests that need relief, but for whatever reasons, maybe the facts aren't perfect, maybe they're not the best vehicle. How do you balance that with the legal strategy of, picking the right cases and making sure you're not taking the wrong case to the farthest extent that they can go, where instead of making progress, you're actually eroding or diminishing the progress that has been made?
Yeah. Do you have, go? No, you go.
We are not lawyers, but we have found all these years, like, for example, impact litigation works for us. Open record request works for us, no, as a way to push back, to see and also to see the information that is coming out, but as well, they have the opportunity to see how many arrests have you made, and particularly that if you arrest 40 persons in a week, just happened that 40 are Latinos, no? So just happened. Entonces, these kind of things, it's for us have been a resource to push back. And we are using it, impact litigation and all these open records, to create these reports that then we go and ask for meetings with sheriffs, local enforcement, local officials, to explain, okay, I have these facts, so just to push back. That has been part of our work. We have been also participating in litigations, for example, against the HB 87 that showed me your papers here in Georgia, as a main plaintiff, and also against the SB 202 that was the voting rights bill here in Georgia. So finding ways to participate and put the legal arm behind, to push back. I don't know.
Thank you for saying that. I just, yeah, this isn't your question, but I just want to say, oh my gosh, litigation is such a powerful tool. It just is. I mean, it just, even when we lose, there's something about standing up for your community and saying that here's a group that is entitled to equal protection and that we're entitled to be heard, just to be heard. That in itself changes things. It really does. You know, I've seen that question posed. I've seen like so many law review articles written about this, about, oh, you know, there's this push or pressure to pick ideal plaintiffs that maybe then don't represent the, you know, I'll just say I've been litigating this and just for LGBTQ stuff for like 30 some years. I've literally never encountered that. I just haven't. Like we pick people have these problems, we represent them. I mean, I just have not, this has not been a thing. I can think of one time where we were doing a school harassment case and there was one kid who had like the way the school had responded to her getting picked on for her gender nonconformity and being a lesbian was to constantly discipline her. So she had this long disciplinary record. And literally in all this 30 years, I had one conversation with co-counsel was like, well, we can't represent this kid because look, she's got all these disciplinary infractions. And I was just like, sure we can. That's part of what happens and that's part of the story we can tell. And we did and we won. But that's, it just, I think, I don't know, maybe did you encounter that when you were?
I think it's different when you're putting
Yeah.
together an affirmative case than
Yeah.
when you're representing somebody who's showed up and you want to take their case to establish a particular legal point. And there, I do think the reason that you may not do this, but I think the
Yeah.
reason to vet plaintiffs is partly because you want the case that you are working hard to put together and you don't have limitless resources, you want the case to be able to get at the issue you want it to get at. And so if the person has some other kind of arrest record or has some kind of other sort of legal complication, which would usually be what I'm thinking of, which, you know, could just, yeah, it's like a red herring, it doesn't have anything to do with the actual case, but like if I'm the lawyer on the other side, I'm going to point to that and I'm going to try to distract the, you know, sort of distract the focus of the court onto that issue rather than the issue. So I think that the choices are real. At the same time, I think that when you make those choices and you win a right, you are winning that right for all people. It doesn't mean you're winning the right for every single issue that comes up. And that's the nature of social movement work. It's the nature of social movement lawyering, is it's piece by piece. You know, so I think it's an important question, and I think what you can take from all of our responses is, you know, the answer is not binary, and nor is the work.
Very good. Other questions? Yes, in the back.
Yeah, thank you all for being here. My question is more at Shannon. So we had heard earlier this morning that the Mercer decision kind of opened the door for a more expansive view of marriage, maybe even endorsing things like polygamy. Now, with the transgender movement, I think that, you know, one worry that people might have is that endorsing transgenderism might lead to the transhumanism that we were both talking, that you mentioned in your speech that we're trying to avoid. And I'm wondering where we can kind of draw a hard line in this, and where you might draw the line between endorsing transgenderism and then the transhumanism movement.
Yeah, I mean, in my opinion, there is like zero logical, material, or any sort of other inherent connection between transgender people and transhumanism. That's probably to do the best job in the world, but that's kind of what I'm trying to call out. Like, there's a widespread view on both the left and the right, certain elements, sort of the two extremes, I would say, of the left and the right, that inherently what it means to be transgender is to somehow negate the material body, to be antithetical to the reality or concept of biological sex, that you're asserting a sort of psychological or disembodied identity that's supposed to take precedence over the person's actual materiality or biology. That is just that's just an ideological view. And that's not how I view transgender identity in any way, shape, or form. I do not think that it has any inherent I don't think it's the truth about transgender identity. So it's only if you accept those premises that there would be some sort of inherent connection between supporting transgender people or recognizing them and somehow, potentially getting into transhumanism. I mean, for example, I think being transgender is biologically based. I think people are born that way. I think it's something to do with your what happens, the interaction between genetics and in utero development. The biological process of sexual differentiation is very complicated. It's no wonder that sometimes there's variations in how that works out, and so you get people whose, your brain sex is going one way and your other physical attributes are going another. I think it's a medical condition that we got to deal with, and to me, there's nothing at all about transgender identity that is in any way opposed to the notion of biology or biological sex or anything like that. But to me, the danger is transgender people actually exist. It's part of, they're part of communities, part of human history forever. As far as we know, it's documented in every human society. It's just dangerous to take a group of people and associate them with an ideology, to impute their very existence as somehow the embodiment of an ideological position. It's just so dangerous to do that. So that's where I think that discourse around transgender identity and transhumanism goes awry. And, so, yeah.
Can I just add something that's sort of taking up your question, which I think has also another interesting piece embedded in it, which just on the marriage front, right? Anytime the state, meaning the government, creates a legal status, let's say marriage, it has to decide who's eligible and who's not. What are the eligibility criteria to enter marriage? And so the state decided, right, that people had to consent and that you couldn't consent younger than a certain age, that parents couldn't marry their children, that marriage was going to be limited to 2. And so in the marriage equality movement, a lot of the arguments that were made, even at that time, were, well, okay, you same-sex couples want to marry each other. I want to marry my dog. I want to marry my bowling partner. And or I want to marry my laptop, right? I guess that was a real argument that somebody tried to make. And the point is that anytime the government is drawing lines, we can always ask why here and what there, and what happens if that line is changed in some way. Does that end the line, right? It's kind of a floodgates argument. You change this, does that open floodgates? Does that remove the capacity for the state to, based on reason, draw lines about who's in and who's out in some sort of status? And we heard this morning, you gave a great paper on, do the lines we have make sense? But I think the fact that a line is challenged with respect to the eligibility of one group of people does not mean that the eligibility of any other person or even inanimate object, walks in the door. Because the question always in law, right, you learn this from 1L year, is you have to look at the facts, right? You can't just abstract cases entirely from the facts. And likewise, even in the equal protection context, we're always asking, well, not why are all groups excluded, right? Why is the line drawn, the classification drawn around this group? So I think the kind of concern you're raising could be anywhere, right? And the state will still, right, and after marriage equality for same-sex couples, still isn't allowing parents to marry their kids, right? Just to take that example. And so I think it's not that at a broad level, sure, there's always a question, but in an actual way courts work level, there's much more based on what are the facts and what are the arguments for and against the validity of this line drawing with respect to this group.
And did you have any more?
No.
Well, I was actually going to say, I think we don't have time probably for another question. Oh, we do? Okay. One more question, someone. Yes.
So
Embrace it and be tolerant. Yeah, I don't think it's one or the other. No, part to embrace others, embrace the difference. It's also part of being tolerant, no, and to understand others the way they are. It's like if you are the chief and you have like 15 people in your staff, no, part of the thing is to embrace, but also be tolerant, because you have to get to know each of them, no, and try to have a good culture inside your group, your organization. But I think it's both, no, because it's part of the understanding, the acceptance, no, of the other is my own acceptance, under my perspective. And I think it's important, no, to use sometimes our privilege, no, to take a stand. I think that all of us who should make our own statement, no, we should take part of what we need to be changed to help others, to help vulnerable people as well, no, communities of color. It's not only about immigrants or trans communities or LGBTQ or African American groups. No, I think it's wider. And part of this is be capable to open your heart, embrace, no, and let's deal it with whatever is coming.
I feel like I'm saying too much. I feel like I'm probably being too candid sometimes, but I feel like we're in such a rough, difficult position right now that it's important to say some of these things out loud. I mean, your question is a hard one. That's a big philosophical question. I mean, I'm just like, I believe in democracy. I think we need kind of rough civil and legal equality. And that's, to me, that is a plenty sufficient goal. But I'll just give an example where I think we've messed up in the transgender movement. Like, there was a time when we would ask people to, just use your pronouns that you use, and if you haven't changed your name, use your name and use the pronouns that you use. And it was understood to be a matter of politeness and civility. It was not framed, and we were not framed, transgender people were not framing it as, you must affirm that you believe that I am really male, in my case, or that a transgender woman is really female. But somehow along the way, we just started crossing those lines and really sort of asking and even sometimes demanding that people agree with these, very sensitive, complex propositions that people have a wide variety of views on and religious views on and all that. And it has not served us well. We're putting too much weight on things like, we'd be so much better off, in my opinion, if we were just like, hey, transgender people exist, we just want to be able to participate, like other people do in society, want to be able to work, have family, go to school, get medical care, have ID. If you could just be polite and just let me live. And yes, in order for me to function in society, I kind of have to be, if everyone's constantly, calling you by, a gender that doesn't match how you're living, it's just going to cause all kinds of problems for everybody. But it's just a matter of civility, politeness, but not insisting that we rest these, make people agree with sort of philosophical propositions that they may not agree with. And the more we've made it be about that, the more trouble we're getting in. To the point now where something that should just be a matter of basic equal treatment, which is what pronouns you use for somebody, has been turned into a free speech issue. Because in too many cases, we're the ones who started to say that it's an expression of a viewpoint rather than just how you're treating someone. And, it's so, I do think I'm very coming at this from inside the transgender movement, and there's some unique issues there, but I think we have mishandled that to some extent.
I think just picking up on what you said and your question, which gets it in some ways like, what's the role of law? Which is a little bit of a question I asked earlier. There is a way in which law, as a phenomenon in society, is like one of many influences on people. Like there's law, there's pop culture, there's family, there's faith, there's all of these things that may shape our values and what we believe. And law, I don't want to say law has no effect, but I think lawyers tend to think it has more effect than others. So I used to say, like, sort of fetishizes the power of law, right? And I wrote an article once where I was like, the fear is, right, the fear of the sex discrimination argument, right, if that were relied on in marriage cases, would be now everybody would have to wear tunics, right, matching tunics. And, that is like, the law is not that powerful. I mean, it's not used in that way right now, obviously. We could be mandated to do that, but the law as a kind of an entry point, or a sort of a lever to change social views it's one in a lot. And on the other hand, I think it's important to recognize that for what it is, but when law changes, right, so that same-sex couples can get married, or undocumented, people without legal documentation can remain in the country if they haven't committed crimes or something, it's like you don't have to, it doesn't mean that everybody has to love gay people. And it can mean that you can still deeply disapprove of, be offended by the idea that same-sex couples can marry. It can gross you out, right? The law is, yes, and for the vis-a-vis the state, these people are eligible to have these rights and benefits that are accorded to marriage. And one of the very interesting questions in the cases that involve people who are running businesses and keeping a business open to the market, right, a public accommodation, a store, is the question, like, what does it mean to serve somebody, right? What does it mean to, make a website or serve somebody a product like a cake or something? And the idea of non-discrimination was never to say you have to like all your customers or approve of them. It is that whatever your views, if you are offering a service to the public, you can't exclude some people. You can't shut some people out of the doors. And so I think, just to pick up on both a mistake, but also just a reminder that when law reform movements seek to change law toward greater equality, it's not actually primarily or sometimes even at all about changing people's minds in that sense. Like the changing hearts part is about advocacy strategy, but the winning a legal right is about non-discriminatory access to something. And I think it is really actually quite important, including as we think about the legacies of Obergefell, to keep that in mind. Like Obergefell wasn't about you have to like gay people getting married. It was about the state has to allow this, and then where married couples are recognized, then gay people are part of, same-sex couples are part of this group.
I think Adelina has one more thing.
Just a little thing is you don't have to love me and you don't have to hate me. Mm-hmm. But I think that I need to be respected as a human being. Yeah. That's it.
I think that's a good place to end. And thank you all so much. I really appreciate our panel. And I want to thank everyone who's here for coming and for staying here with us today. I really appreciate it. I hope y'all have gotten something out of this. I know I have gotten a lot myself. So I really appreciate all of your attendance and all of our speakers, and in particular our law review members and our organizers. And I'll turn things over to, I guess, Seth next and take it from there.
I'll be brief because I know I'm one of the few things keeping you guys from your weekend. I just want to thank a few people specifically for really helping make this event happen. Obviously, our panelists, thank you all so much for coming here and joining us and speaking. I want to thank the Dean Suite, specifically Bernadine and Tracy Jackson, who I know are not in the room right now, but they have been instrumental in making sure that this has happened. To IT, to Dean Snedden for supporting us, for Professor Byers for supporting us in this, but to our moderators for again joining us. But specifically, the two people I would like to thank most of all are the two people standing right here. To Devin I don't think there's anybody else in the world that could have made this event happen. Professor Titshaw, thank you so much for trusting us with your event and making this happen. So can we please give them a round of applause? I too will be brief. It's bad enough you had to hear me talk twice already. Thanks again to Seth Lewis. Again, I could not do any of the law review tasks that I succeed at without Seth and his constant support. Professor Titshaw for being the visionary behind this symposium, from imagining a keynote speaker who was an architect of the Obergefell decision, to the panels that got to explore the consequences of what he built, both in terms of constitutional law, to the family law implications of the Obergefell decision and freedom to marry movement, implications that none of us may have ever even imagined 10 years ago, but which were so interesting to explore today. I want to thank the entirety of the Law Review and to anyone here today who asked thoughtful and provoking questions, for allowing yourselves to be maybe intellectually challenged in certain ways, and for just embodying the best of the Mercer Law Review and coming here with academic freedom and intellectual curiosity. So I just want to thank everyone, and congrats to everyone for seeing a success here this weekend. Thank you.